Good morning. Good morning, everybody present. I would like to welcome you to our day 2 of the Kenya School of Law annual conference. This is the 5th annual conference. The theme being taxation, socio-economic development, and legal education. So to start this morning, I would like we can stand so that we start with our word of prayer. We are praying. Our Father in heaven, we are grateful this morning for the gift of life and health that you have granted us. Lord, we thank you for being with each one of us. We thank you even since yesterday you have guided us in this program. Lord, this morning we want to start and we invite your presence to guide us. Be with us, give us wisdom, even the discussions that we are going to have, Lord, they may be useful to advancing the objectives of this conference. As we discuss legal education today, Lord, we pray that you'll guide us. Be with our speakers. We'll be speaking this morning and later in the day. Lord, and even the participants who are coming from different places, we pray that you guide them to join us so that we're able to continue together. We pray all this in Jesus' name. Amen. So once again, my name is Kuloba Isaac, Assistant Director in charge of CPD. That's Continuing Professional Development Projects and Research at the school. I take this opportunity to welcome those who are present here physically and those who have logged in online. We invite you to participate in the programs that we have today. Yesterday we started well. We had a number of presentations on mainly focusing on taxation, social economic rights, and related issues. The discussions were very fruitful, and we thank you for having been present online and physically. So today, as I said, we are starting this morning with 2 presentations on legal education. I'll be inviting the director of the Kenya School of Law, Dr. Henry Mutai, to also welcome you and also introduce the speakers this morning. So we'll have a plenary discussion after the 2 presentations. We'll have questions and answer sessions and your contribution. So if you are logged in online, feel free to post your issues on the live chat. You will be able to address those concerns. Otherwise, karibu sana. Today, our MC this morning is Mr. Samuel Maniki. He's present here. He'll be taking us through the session. Karibu sana. Welcome, Director, to make remarks and invite our speakers this morning.
Thank you very much, Isaac, and good morning, everyone. So our 2 keynote speakers for today, Professor Collins Adote, the Chair of the Council of Legal Education, and Mrs. Emily Chair from the Office of the Attorney General, and our board member here at the Kenya School of Law. Ladies and gentlemen, I will keep my remarks fairly brief. Today's topic, especially, we find ourselves in a time where a lot is changing in terms of the world and society generally, and the legal sector cannot be left behind. As the ones charged with the duty of educating the next generation of professionals, we have to make sure that the education that we provide is fit for purpose. So it has been a long time since there were changes in the legal education sector, And there have been proposals along the way for various changes to be made. But one of the big gaps has been the fact that we do not have a legal education policy in the country. So changes have been made in a very haphazard and ad hoc manner. So I know that the Office of the Attorney General has been working on this for some time, and we are delighted that we shall be getting an update on the status from Mrs. Chua. But first, we shall also have, or we shall have a presentation by Professor Odote talking about the need for change and the pathway for regulatory reform. Us here at the school, we are just a legal education provider. As per our mandate on behalf of the government, the council is the one that regulates the sector in terms of legal education. I know last week they launched their new strategic plan, setting out what they aim to do over the next 5 years. So maybe as Professor Odote gives his presentation, he shall be able to share with us some of the ideas of the council and some of his ideas also as a long experienced professional in this field. So without any further ado, I shall invite our first keynote speaker, Professor Collins Odote, Chairperson of the Council of Legal Education. He is a professor at the University of Nairobi School of Law in Parklands. And I'm sure if you go to their website, you shall get more details of his very long and detailed curriculum vitae. Professor Odote, welcome. The floor is yours.
Thank you very much, Henry Mutai, Director, Kenya School of Law. Ladies and gentlemen, both those here and online, good morning.
Good morning.
It's a great pleasure to be here. Since I became chair of the Council of Legal Education, Henry and group have invited me to several functions of the Kenya School of Law, including their celebrations last year. Including the graduation, but I wasn't able to come. So when this invitation came, I think over a month and a half ago, from Cornelius Lupao, I purposed that whatever happens, I will be able to come. I think as young people, you know that people used to write letters to their girlfriends and say, even if it rains, come rain, come sunshine, I will come. But if it floods, I will not be available. At least I did not use that excuse. I'm very glad to be here. I would like to share just a few thoughts in terms of the need for change in legal education and the pathway for regulatory reform in that process. And just as we were starting, we were having a conversation with Emily and Henry, and Mrs. Chua will be speaking about the legal education policy, amongst other things. And the director of KSL said two things. That number one, you know, lawyers will always have something to say. And then it says, and on this question of reforms, there's always been a heated conversation with those for the status quo and those against the status, those that think that change must happen. I think it's important for us to reflect, though, that we are at a critical inflection point as a sector. 60 years after the Lord Denning Committee of 1960, that then set the path for what we have as legal education in this continent and also in this country, where we moved from training people by the colony, for the colony in Britain, to ensuring we have our own training in the country, and that training was going to be focused on local context. I think 60 years later, that vision that was set by the Lord Denning Committee may have served us for many years, but it might be time for us to relook at it. I think if you look at the history of its implementation, we have tried to make changes here and there. We've had several task forces. I think the last critical task force, just to underscore the importance of this conversation, was the Jambo Task Force that then finalized its work in 2018, but whose findings have not been fully implemented. I think I was having a conversation with the Attorney General just last year to say, you know, although we had the Jambo Task Force report, which we haven't implemented, several other things have happened. When the Jambo Task Force was going around, if you came to this meeting and you had this number, and you'd complain, where are people? But now, we know that meetings does not have to take place physically. Yesterday, I was interviewing somebody, and then we agreed on to a time at 3 o'clock. As far as I knew, I was supposed to do the interview online. Then he says, I thought the meeting was physical. And I said, who has physical meetings in this day and age? That also has implications on how we teach law and the place of technology. And I think those kind of conversations are important to have. I think anytime people hear about change, you tremble. I'm sure yesterday the CS for public service must have been discussing with us the imperatives of moving civil servants from permanent to contract. And there must be those of us up in arms. But assuming that you are having 4 years to retire, Emily, the conversation as to whether you're on permanent or contract is, strictly speaking, a non-issue, isn't it? The question must just be under what terms and what problems being solved. So I think it's always important for people to understand that change is the only constant thing in society. And I'll be showing in a short while that the conversation about change in legal education is one that many countries continue to have. But I think for us, as we have that conversation, there are several things we need to reflect upon. I think one of the things that continues to be controversial is about the question about the structure of legal education. We currently know that when we talk about, we say there's education and then there's training, the two-tier system. Education takes place academically at the universities, and then training takes place through the ATP program. So the question that people keep asking, should we continue having that bifurcation? Do we need to continue having education, academic education in universities, and then having vocational training at the ATP level? Yes or no? Just this morning, I was reading some paper about South Africa having the same debate in their legal curriculum and saying that even thinkers need to know how to fix pipes. And they're trying to make a case for introducing a course of trial advocacy in their curriculum. And I think it all boils down to the structure of legal education. What kind of legal education? And with CBC coming, I'll be talking about that in a short while, will law continue being 4 years, or will it be 3 years as CBC envisaged? And if it's to be 3, what does that mean in terms of what we teach? The second is the nature of our curriculum. If you look at the 9 Ps, for example, Monique, what do those 9 Ps focus on? What courses do they teach? We have criminal procedure, we have civil procedure, we have commercial practice. If we take commercial practice, for example, let's take conveyancing. As we convey, when we went to law school, conveyancing was about selling land. In this modern age, with issues around data, with issues around shares, what we convey also has changed. What does that really mean in terms of the nature of our curriculum? But also, even for us, the kind of regulatory framework that we require. We just inspected KSL a short while ago, and you will see as we are inspecting universities, we keep asking, how many books do you have? Please show them to us. What kind of physical facilities do you have? Post-COVID, you see, you can have a meeting of 1,000 people in a room of 50, because those 950 are online. Before COVID, you needed to have physical space of 1,000. But that's our regulatory process, both for academic legal education, for ATP, for paralegal education, and for pupillage. Are they in tune with what is happening? But also, if we're honest with ourselves, I think to a large extent, at all those levels, including at the ATP level, I think there's very limited practical skills development that we focus on and we need to think about. And then second, lastly, in terms of the landscape, budgets, a 30% budget for the faculty you need to have. What does that mean about the infrastructure? You have a 30% budget cut, but CLE will tell you, I require you to have this amount of books. When you go to your budget for books has been reduced, like everything else, by 30%. How do you balance those two? But also, for me, the policy and regulatory framework. We continue to have huge debates between what does the KSL Act provide and what does the Legal Education Act provide. Are they speaking to each other? What does that mean? What does the Legal Education Act provide? What does the Universities Act that mandates Q provide? Are they speaking to each other? So that policy and regulatory incoherence are challenges that the sector continues to grapple with and we need to worry about. I think, in addition, the nature of the practice of law has changed, and therefore even the question about who is an advocate has changed. A few weeks ago, actually 2 weeks ago, I was watching the interviews for judgeship, and one of the people who was being interviewed was asked the question that, we see that you have worked at the UN, we see that you've worked at the county level, but what experience do you have in legal practice that would make you suitable to be a judge? And the question that came to my mind, today in the 21st century, what is legal practice? How many of lawyers in legal practice, in terms of absolute percentages, go to court on a day-to-day basis? And how many practice law outside courtroom? In the traditional sense, Emily, who has worked for a long time in the AGs, working on police issues, are you a practitioner? We think no. But is that really true in the 21st century? Is that really true in 2024? So what does that mean to be an advocate? I think something we need to think about. I think the next thing is the quality of legal education and the quality of legal education providers. I think the debate between quantity vis-a-vis quality. How many lawyers are enough is the question you continue having, not the question about what kind of lawyers do we have. I continue giving the perfect example, is that when we have the challenge of Mwenda of this world, it is not enough to ask which law school did Mwenda go to. It's much more important to ask ourselves, what does it mean when we have a society where somebody who has not gone to law school and hasn't gone successful can actually practice law? When Okia Omtata practices law much more than Monique, do we require legal education? Is it necessary? If I can be able to have a successful legal practice without having stepped into a law school. And the ones who step in are regulated. The ones who don't step in are not regulated. What does that mean about the work that we do? I think if we don't ask ourselves those critical questions, we will essentially be speaking to things that are not real. But the good news, ladies and gentlemen, is that those challenges are not challenges just for us. I will share with you, I think, 2 quotes. One, I was reading some document in 1975 called Legal Education in a Changing World, Report of the Committee of Legal Education in Developing Countries. And if you read, and I won't read all of it, but if you read that quotation, you see it is complaining about how we measure quality of legal education, the matrices we use for measuring quality. And says, for example, that the academic program of university law schools has not in many ways kept pace with the development of other disciplines, and that quality can be measured by exams, quality can be measured by the intensity and diversity of education experiences, by the kind of motivations, but it can also be measured by the degree of continuous innovation and ferment within the discipline, the quality of how you challenge yourself. But it says, if you assess them by these matrices, the quality of many institutions has been low, though in many settings, efforts are underway to change. So in 1975, they were complaining that both in terms of our exams, in terms of how we challenge ourselves, in terms of what the motivations that make us go to law school, if we measure about that, then legal education was not delivering. The question is, if you take that quote and remove 1975 and replace with 2024, the question you must ask yourself is, what has changed? And not what has changed for KSL, not what has changed for the University of Nairobi, not what has changed for Moi, because that's the most convenient thing to say, comparing one against the other, but what has changed about legal education in the country. So if that is in 1975, developing countries, you can say, no, that's a challenge for developing countries. But here is a quotation in 2020 in the US. And the US, the American Bar Association, established a commission on the future of legal education. And that commission came up with a report, and on the report, ranging from how bar exams are done, ranging to the place of technology, ranging to our approach about change itself, ranging to methodology of trainings, they returned a verdict of suboptimality in terms of legal education in the US. Just 4 short years ago. A short quote up there where they say that our established system of legal education and licensure is preparing the next generation of legal professionals, some of you sitting here, for yesterday rather than tomorrow. It is preparing for a world that will not exist sooner than they might like to imagine. And I think one of those critical conversations is AI. I think a few weeks ago, no, actually a few months ago, there was a whole debate between the profession and the judiciary concerning Huduma centers and the use of technology. Fair enough conversation. But in that process, the debate then quickly turned into what is the place of technology in legal practice. I was having a conversation with a friend of mine who sits in the Council of Legal Education, and was making the point that, 20 years ago, we would hire young lawyers to prepare charges, to prepare the benches. Now, that document can be gotten through AI, and AI will be 80% accurate and 200% more efficient. So the question that you must then ask yourself, in light of that, what kind of lawyer do we require? But a lot of the times when we train, we are still training you to look at, so how does a charge look like? How do you draft it? Without realizing that 80%, it will be generated through technology. What you require is that 20% critical knowledge. What does that mean for how we train our people? I think a challenge coming from the US that we then must deal with. I think, colleagues, it is therefore clear from that conversation that reform is absolutely necessary. It is necessary for many reasons. Number one, global trends in legal education. I've just shown you the conversations in the US. I've just had with you conversations in South Africa. In, I think, Malaysia, they're actually training lawyers in civil law too, yet they're a common law country. Because they're saying the bulk of our clients are clients who are from a civil law jurisdiction. So this dichotomy that we are common law, therefore we cannot learn civil law, we can't undertake any longer. Because if we do, we will continue suffering. I think if you come to this country, for example, you have seen over the last 5 years the amount of foreign law firms that are finding place here. So you will see Kenyan law firms in partnerships with South Africa, and you must ask yourself, why are they having partnerships with us and setting base here? It must mean there's something that they have seen in the market that they want to exploit. The question we must ask ourselves is, how do we ensure we are on top of those global trends? Number three is that we need to adapt to technological advancement. Therefore, we must ask ourselves, what kind of lawyer do we require in Kenya? And therefore, what kind of legal education is necessary for that lawyer? That's where my conversation about, so what is practice? Because if we continue to only train those that go to court on a day-to-day basis, we are training 20% of the legal profession. And number two, even at that courtroom, if we don't recognize that, by the way, there is non-lawyers who are also now practicing, how do we ensure there's a difference between the lawyer who has gone to university and the one who is practicing as a public interest litigator but has not gone to law school? That must be a question we answer through the kind of training that we provide for those people. It's for that reason, ladies and gentlemen, and Dr. Mutai just told you a short while ago, that at the Council of Legal Education, over the next 5 years, we think that there are a few things that are important for us to focus on. We are clear in our mind that as part of our regulatory mandate, we must modernize the curriculum for legal education. And that curriculum for legal education is at all spheres. We must relook at the university curriculum. We are required to do so anyway because of the competence-based curriculum. The competence-based curriculum that will require us to change several things. One, in terms of what courses, how many, because the number of years may most likely change from 4 to 3. Therefore, we must rethink about which are the critical ones. But number two, we must also change how we train. The CBC kids are being taught in a manner of facilitating learning as opposed to instruction and rote learning. We must be adept at it. But number three is even in terms of how we assess. We currently are focusing on outcome-based assessment. You come to class for 15 weeks, then you do an exam. CBC is much more about assessment. We need to think and be ahead of it. So I don't think we should wait until 2029 to relook at our university curriculum. So at CLE, we are focused that from next year, we must start the conversation with law schools so we can be ahead of that conversation. But number two, we must also relook at the curriculum that KSL offers here and that CLE examines, so that it's also aligned to that change. There's been a start of conversations about the paralegal curriculum. Should paralegals be regulated or not? If so, how? The conversation about what happens to people who come and do a diploma in law, can they move up or not? I think that's a conversation we must have. Fourthly, we must reform how we administer bar exams. When I took over as the chair, the first thing that inundated me was complaints from students about how the council administers bar exams. We must ensure that those exams are not life and death. We must ensure that while we maintain quality and credibility, it must be much more predictable, it must be much more responsive. Second is just building on this part, what I said a short while ago, and segueing to what I think Emily will talk about. I think we must be able to deal with policy and regulatory reforms. Currently in Parliament, there are piecemeal efforts to amend each of our laws. I think it is wrong for us to continue with piecemeal efforts. We must have a much more comprehensive look at the legal framework so that the laws speak to each other. There shouldn't be a distinction between the KSL Act and the Legal Education Act. There shouldn't be a distinction between the University Act and the Legal Education Act because we are regulating the same sector in the same country. Therefore, the laws must be able to enhance coherence and not provide discordance. The National Legal Education and Training Policy that the Ministry is working on is long overdue. I think it needs to be finalized, but it needs to be finalized in a manner that speaks to the future of the legal profession and not the past. We also need to review the standards and guidelines that we use as a council for regulating legal education and training. Importantly, if you support Liverpool, and I was saying this last week, my son is a supporter of Liverpool, so 2 days ago, when they lost, he actually broke the mirrors in the room. And when the mom went to tell him that, no, Dad, it's okay, he told the mother, you know, you don't understand. You don't understand what this is. But the important thing about Liverpool is the tagline for Liverpool is, you will never walk alone. Therefore, this journey of regulatory reforms, of change, we must be able to collaborate and partner much more. We must be able to ensure that the work that the council does, the work that Kenya School of Law does, the work that Kenya Law does, the work that universities do, are coherent. Because at the end of the day, when people judge, they don't judge one of us, they judge the sector. When I took over as chair, one of the very big politicians in this country called me and told me, you know, my ex wanted to be admitted to ATP, but you told him that they required Y Can you extend the time so that they can be able to bring the certificates? When we finished discussions, I knew he was talking about the Kenya School of Law. But he was speaking to me because he was sure I am the chair of the Kenya School of Law. So if that is a top politician who doesn't know the difference between Kenya School of Law and CLE, it just means that our approach of thinking that there is a separation between our different institutions will not help us. We must be able to collaborate and partner because the challenges are challenges that we know the challenges, we don't know the answers, and we require collaboration to be able to get those answers. Over the next, because at the end of the day, colleagues, just as our new vision talks about, we must have innovative legal professionals transforming society. Legal education must be seen as a, because all citizens are looking for is improvement in legal service delivery. If we are supposed to be the defenders of the rule of law, when rule of law breaks down, what does that mean for how we train? If you watched yesterday and you saw the floods and you saw the number of people dying, then we have universities that say, including the one where I teach in, saying our niche is environmental law, isn't it? So if your niche is environmental law, when flooding takes place in Nairobi, what has legal education done in terms of responding to that? Because that, for me, is the conversation we must be able to have. A lot of lawyers are in counties, county attorneys. When there are challenges around how counties are run, the question we must ask, what's the place of legal education in addressing that kind of issue? Number two, through legal reform, we must enhance the competitiveness of legal professionals. If you go to international bodies, we must start asking ourselves, how many Kenyans are on those international bodies? The UN is just here. How many Kenyan lawyers are in the UN? What are they doing? How are we preparing them for them? Or are we preparing our people only for Milimani law courts in terms of how we train? I think it's a question we must ask. We must be deliberate about it. So we must be found in Milimani, we must be found in Kajiado, but we must also be found in UNEP, we must also be found in WTO, we must be found in ICAO, the one for civil aviation. That's the kind of conversation we must have. We must also ask ourselves, what's our contribution to national development goals? Yesterday you're having a debate on tax. So as we're looking at our taxation policies and laws, what's the place of lawyers? Because at the end of the day, we must catalyze societal transformation. In the past, we've done a very good job as lawyers. If you look at the move for the second liberation, I think the political conversations and new constitution, lawyers were at the forefront of that. But I think we must stop getting stuck only at constitutional reform. We must look at transforming society socially, transforming society economically, transforming society culturally, in addition to the political aspects of reform. And that's, I think, a conversation that legal reforms will help us to deal with. But for us to do so, we must then address the challenges that I spoke about at the start, and I don't want to rehash, except to say, as I end, that change is urgent, colleagues. If we don't change quickly, when we have a conference, Henry, 5 years from now, we'll be asking ourselves, who moved our cheese? Because the cheese will have moved. The reality today is if anybody has a great public interest matter, they will not look for James Orengo. They will not look for Colin Sodota. They will not look for Monique. They will not look for Mutai. They will most likely look for Omtata. He was one, they're now two. Soon, they may be 2,000. So therefore, we'll find that the people practicing law who are not trained in law are more than those who have been trained. But for us to deal with that, we must ensure that we recognize the urgency of the moment. Number two, we must enhance the collaboration with stakeholders. And number three, we must ensure that conversations like today, the continuous introspection, are a continuous focus of our work. In doing that introspection, in making the change, we must stop focusing on tactics. We must focus much more on strategies. We must focus on systemic issues and not symptoms in the reform process. So the question must not be who is doing what. The question must not be how many chairs you have. The question must much more be what kind of results are we producing. It is for that reason that at the Council, I am completely desirous of ensuring that in a few months we are able to have, just like the American Bar Association had in 2020, conversations on the future of legal education. So we can discuss all the issues openly and be able to explore the different alternatives and be able to try and propose solutions that continue making us the country with the best legal education. We should not just compare ourselves with the region. We must ensure that we are globally competitive in terms of legal education. That is only possible if we don't think we are the best. We must continuously challenge ourselves, because I think it's the late Michael Wamalwa who used to say that good must give way to better, and better must give way to best. And I think that's, for me, the conversation we need to have. I want to thank you very much for the opportunity and hope that you'll have a very successful day two of the conference. Thank you very much.
Thank you very much, Professor Odote, for capturing very succinctly a lot of the challenges that we face. And your presentation brought us very nicely to the next speaker, who is, as I said, Mrs. Emily Chwea, a board member here at the Kenya School of Law, and working at the Office of the Attorney General, who shall share with us an update on the National Legal Education policy. After she finishes, I shall hand over to our moderator to handle the plenary session. So, Mrs. Chair, you are welcome to the podium.
Good morning, everybody. Yes, as you've heard, my name is Emily Chwea. I'm a Director of Legal Affairs, Office of the Attorney General and Department of Justice. Now, I'm here today to really discuss a very crucial topic and to represent the AG in the discussions on the development of a national policy on the reform and modernization of legal education and training in Kenya. Indeed, I've been very, very pleased with Professor Odote's presentation, which has really set the groundwork for the necessity of a policy to really operationalize or modernize legal education in Kenya. Now, just in terms of context, a policy really is a broad course of action adopted by nations, by states, to address certain specific issues which affect the country. The policy will then provide guidance for decisions government makes, for actions that it takes, so that it takes this action in a wholesome manner, not piecemeal, not ad hoc, but in a wholesome manner that is acceptable by the rest of government and the people. So for some time now, the various stakeholders, the Attorney General, the JLAC, that is the Justice Legal Affairs Committee, have been raising issues of some challenges that are affecting Kenya, the legal education in Kenya. Matters come before the JLAC committee, they reach out to the AG for responses, for answers, and it's become a bit difficult because we are not really getting the information, good information on the ground. So it's important to look at all the issues in the country and agree on the best way forward. Now, why is it important to have a legal education policy in Kenya? It is because lawyers are very, very important, play a very, very important role in any nation's social, economic, and political development. They're instrumental in upholding the rule of law. They're instrumental in ensuring economic development. They're instrumental in ensuring respect for human rights, political rights, and good governance. Look at economic development. Lawyers are responsible for setting out a secure legal environment to attract investor confidence. They are responsible for facilitating contracts, facilitating legislation, drafting legislation, dispute resolution. And when I speak of lawyers, of course, I mean the whole spectrum. Lawyers, judges, private lawyers, public lawyers, students, even the students are part of this whole spectrum. So lawyers, in terms of human rights, they give legal representation to challenge violation of rights. Political rights, they are actually represent election disputes, persons in election disputes, draft legislation to ensure free and fair election. So they play an important role in the entire country's development with regard to economic, social, and political. That is why the AG felt that, was of the opinion, that a strong legal education system is crucial to empower lawyers to be able to play this very, very important role of ensuring the country's economic, social, political well-being. So there have been various initiatives, very, very positive initiatives to improve the improve legal education in Kenya. You will remember the Acumen report. You remember the Ministerial Task Force on Development of Legal and Policy, or Legislation and Policy on Legal Education. You remember, which was headed by Professor Gidu and was instrumental in separating the training mandate of the Kenya School of Law from the regulatory and examination mandate of the CLE. We also had recently the Task Force on Legal Sector Reforms, which did an evaluation of the legal sector in terms of legal education, practice, and discipline, and came up with various recommendations. And one of the most important output of that report was the new Advocates Bill. I don't know if many of you have seen it or heard of it, but it's currently before the Law Society of Kenya, and that they are undertaking public participation on it. I know I have an advert in my file calling for more comments and views on that bill. It's going to totally overhaul the act, the original Advocates Act, and I really urge all of you to look at it and to give your views. Now, while these improvements from these task forces have been quite good, they've moved us to a place where we are now, but there's need for more work. The AG, the JLAC, they are of the opinion that there's a lot of rapid advancements in technology and new emerging social issues that needs to be tackled before we can really have a legal education that represents, that infuses new methods of teaching. So our office has been going around trying to get information to come up with a comprehensive policy. It has not been very responsive, but we're able to come up with a draft policy. And we undertook several online meetings. We even posted the advertisement in our website, AG website, but we got no response, surprisingly. But at least we got a few issues, and some of these issues we got from JLAC, from stakeholders, and from the AG. So some of the issues, I have a few, are with regard to rapid technological advancement, which is my good friend here has spoken about already. You know, now we have issues like cyber crime, artificial intelligence. How are we going to deal with these matters? Indeed, I hear that there's the potential risk of artificial intelligence taking over some of our jobs. So we really have to look at it and see how we move forward. We also have issues of online platforms. And there have been efforts to move into online exams, but which is wrought with a lot of issues and problems. And even the artificial intelligence, we had on social media that there's a lot of cheating in it. So there's need to look at it, all these issues comprehensively and get solutions on how to address. Secondly, issues that have also come to our attention through JLAC with regard to East African integration, which in terms of free movement of workers. It seems that it has not been working very well because, firstly, the issue of reciprocity. Apparently, while Kenya opens up its borders for other countries to come work, lawyers from other countries to practice here, to come to school here, this is not done by the other countries. And it's been a big, big issue because other countries then put impediments to try and stop the Kenyans from going that side. Okay, the Advocates Bill is dealing with that because, and even the task force said that we need to put rules and regulations, conditions in place, so that if you don't allow Kenyans to come in, then the Kenya government will also will not allow you. But the issue now is other parts of government are feeling that, no, this is not right, because as soon as you put some of these impediments, you find other countries now start putting impediments with regard to trade. They will say that the Kenya trucks now cannot enter their country, the Kenyan what cannot do this and this. So it's been a big debate, it's been a huge problem. So we feel that we should subject this discussion to the people of Kenya and see how we can move forward. Secondly is the issue of lack of uniformity on qualification for admission to study in Kenya, to study law in Kenya, and to access bars of the East African Community countries. Yeah, that was in the Common Market Protocol. We were supposed to recognize and align our qualifications across the board. But it seems that the other attorney generals have not signed that agreement. I think it's only our AG who signed it, but all the rest have not. They're delaying it. So it's just another issue because it also hinders the agreement with regard to free movement of people. Other issues are in terms of decentralization. You know, there's been advocacy to decentralize legal education. In fact, there are 2 amendments which have been put down: the Kenya School of Law Amendment Bill and the Legal Education Amendment Bill. But these bills, whenever they're taken to Parliament, it's like Parliament doesn't understand, is not sure of what is all this about. So they keep returning them to us, to the office of the AG. So this is an issue then we should sit down and discuss it further and look at the pros and cons. It's okay, we can decentralize, but what does that do to the standards? What does that do to the cost? So there's need for a conversation around that, more conversation, so that even as we go to Parliament, we are able to explain properly on what it is all about. Thirdly is the issue of regulation of legal education. I know there's a court decision on that matter, but that doesn't harm the discussions, the conversations around that area, regulation of legal education. And then we got a lot of information from students on the cost of legal education. Apparently, it seems it's becoming higher, and as the country is going down a difficult path with regard to budget and resources, this is something that really needs discussion. Other issues were progression from diploma to admission. As you know, as of now, it's not possible to progress from diploma, university to admission. But there are stakeholders who put this up and told us to discuss it further. And then there's the issue of multidisciplinary courses. It's no longer just about law, like Professor has spoken about. We need to have skills and knowledge in other areas so that we're able to advise properly. And then, having expanded skill sets. So these are just some of the challenges that we are facing that we need to have a policy to deal with in a more wholesome fashion. Like we've been told, we should not just have piecemeal legislation. You take it to Parliament, it is passed, but 3 days down the line, there's a problem you have to review. We keep reviewing laws all the time. In fact, my good boss and teacher, Professor Gidhu, when he was the AG, he told us that you must ensure that policy precedes legislation. You have the policy, because through the policy, you can get a bird's eye view of what is happening nationally and even internationally, through stakeholder reviews, through public participation, through studying best practices. So you are better off having a policy, however small, to inform this legislation before they are passed, and to ensure that everybody understands what this legislation, the pieces of legislation are all about. Now, we have a draft policy on the modernization of legal education, very draft, 0 draft. We managed to get some information from a few people, but it has not been very responsive. So that is why I do want to to present it here today, because I don't want to stifle ideas. I don't want to lock you out so that you just concentrate on a few issues that we have. I just wanted to open up your minds so that you give us your challenges from where you are sitting, from where you are, from where you are listening. So, so we are here today to really solicit your valuable insights. We want to hear from you as practitioners, lecturers, judges, public officers, private citizens, students, on a number of issues. One, what are the biggest challenges you face in the legal sector? That is one. What skills and knowledge do you believe future lawyers should have? What aspects of legal education should be prioritized in the policy? Now, I will just repeat so that, because today for me is just to collect information with regard to the challenges that you're facing. So I want to repeat it again. What are the challenges, the issues that you face in the legal education sector, in the legal sector itself, practice, or even discipline? What skills and knowledge do you believe future lawyers should have? What aspects of legal education should be prioritized in the policy? Now, as we draft the policy, we cannot just sit in our offices as AG and draft this policy. We need the input of all stakeholders. So we are the AG has directed the setting up of a steering committee really to offer oversight and leadership over the drafting of the policy. So of course we have the traditional stakeholders, but these are the AG's office, Law Society, the universities, CUE, the Kenya School of Law, the CLE, in that. So once we receive all the information, we'll sit down now. The AG will appoint the National Steering Committee, who will then now move forward with the policy itself. So we feel that by working together, we can create a modernized legal education system that equips Kenyan lawyers with the skills and knowledge they need to excel in the 21st century and contribute to a more just and prosperous society. We from the Office of the AG encourage you to actively participate in these discussions. Share your experience robustly, engage freely, make suggestions so that we can ensure the new policy effectively addresses the needs of the legal profession in Kenya. Those are my few words, my presentation. I wanted it to be as short as possible so that I have time to really collect the views that you have in this matter. I thank you.
Good morning, everyone who's present here physically, and good morning to our participants who are online. Thank you very much, our two presenters this morning, our two keynote speakers. You have done very well to raise very, very pertinent issues about these very important subjects on legal education and training in Kenya. Professor Odote has posed very, very important questions on what is the past, where are we today, and what is the future. Very, very important because, as he said, we have had lots and lots of discussions on legal education and training along the way. After every few years, we make some changes here and there, which is all very well, because change is a constant factor in the world. Mrs. Chair has told us that there is an ongoing conversation about the need to develop a national policy on legal education and training. And she correctly indicated that ideally, legislation should come after a policy document. The policy should precede legislation, so that you're writing some law to implement policy decisions that have been made, through a very, very participatory process. And that's a good thing. So just before we allow them to leave, would like to take some questions from participants here present physically, as well as those following us virtually. Please send, those who are online, please type your questions on the chat. There's somebody monitoring that, and we'll be happy to read them out here and request our presenters to respond to them. All right. Let me see. Okay, we have some hands. We can start at the back over there. Let's start at the back. For once. Let's start from the back. Please be, just say your name and then be very brief, clear to the point. It's okay to indicate the speaker that your question is addressed to. Please be brief. Be brief. Yeah.
So I feel like the aspects are the knowledge. Thank you. The skills and knowledge that future lawyers should have should be geared towards understanding the interplay of artificial intelligence, both in practice and application of law. And what aspects of law should this policy be about will actually border on that first suggestion. To Professor Odote, my question rotates about the nexus between studies and setting of exams. Having been in platform with the previous students who have been here, there is a worry that sometimes what we study and what ends up being set by CLE are rather contradictory. So perhaps would you address on what dictates CLE setting standards and what is the nexus between what we study here and the exams that is set? Thank you so much, Mr. Mwanike.
All right. Thank you, Mr. Gola, for those questions. We had some hands up down here, please.
Good morning. My name is Ian, and my question goes to the good professor. You've talked about aligning the law curriculum with the CBC so that it can fit the 3 years. I would like to link that with another issue you've raised on the need to align this curriculum with the changing needs of the society. Now, in my understanding, law practice in other jurisdictions, specifically the US, is offered as a second degree, in that one is supposed to have undertaken an undergraduate degree before now doing law. And the rationale for this is that it offers a wide perspective in legal practice in the legal profession. So linking those two issues, what do you think is the feasibility of this approach now looking at the legal education in the Kenyan space? Thank you.
All right, thank you, Ian. Whether LLB should be a first degree or a second degree, thank you.
Thank you so much for this opportunity. My name is Otieno Bill. I'm a student here. My question is directed to Professor Odote. I recall the unfortunate incident of Brian Mwenda and the other people who have been masked out for masquerading, and the conversations that were surrounding the incident, and some people were suggesting that maybe we could make some changes to the legal profession, in that we could introduce the concept of recognition of prior learning. And there's a bill there are several bills that have been introduced in Parliament. There's one by the woman rep for Kirinyaga, I suppose, that wants to lower the entry requirements for advocates or lawyers in this country. And I think one of the justifications for that stance was that in order to root out these issues of masquerading, we ought to lower the entry grades. So what is your opinion on this? Should we use recognition of prior learning as one of the methods of admitting advocates? And what is your opinion on lowering the entry grade vis-a-vis the quality of lawyers that the country will be producing?
All right, thank you, Otieno. The question of academic progression is a big question. I suppose that we'll need to go into the policy that's being, it has plagued the Kenya School of Law and CLE for the last, 12 years now. The last 12 years, the issue of academic progression is still a big problem. I think Kenya School of Law must have the world record for the bar school where a substantial number of students get admitted on the basis of court orders. I think we have a world record. Please proceed.
Yeah, good morning. My name is Isaac Maina, and first and foremost, I would like to say thank you for the presentations. I believe we are all in agreement that the presentations have been very insightful. My first question is about, in terms of harmony in the legal education, whereby you get, there are students who, let's say, it was mentioned that somebody cannot proceed from a diploma to a degree. But you get that some students, there's a requirement whereby they normally say when you want to do a degree, maybe you have a B in English or Swahili. So you get that some universities admit a student maybe based on Kiswahili, but in terms of now coming to the Kenya School of Law, they are told that they are not qualified to join ATP. So the question is, how are they admitted to university, but in KSL they are told that they are ineligible? Shouldn't it be like everywhere? If it's KSL, you're ineligible. If it also comes to undergrad, you're ineligible, so that you are not taken through a whole degree program only for you to be told at the Kenya School of Law that you're ineligible to join Kenya School of Law. Yeah, maybe because you proceeded from a diploma to a degree, but when you come to KSL, you're told you're ineligible. So what are you going to do? I think you should have been told from the word go, you're ineligible. Second question goes to Ms. Chua. Opportunities maybe that the AG office offers in terms of maybe incorporating law students, in terms of, building their capacity, not just maybe in pupillage, but even before, during the undergraduate program, just in terms of, reaching out to maybe law schools, taking in law students, and also just teaching them in terms of matters policy. I think that this is also help students in terms of letting them develop their skills in the legal aspect, in the practical aspect. Yeah, thank you.
All right, thank you, Isaac. All right, we have a hand here, then one more at the back there, then we can get our speakers to respond to those ones. Our participants online, we continue to encourage you to please post your questions in the chat.
Okay, good morning. My name is Silas Mburuki, a final year law student at the African Nazarene University. And I have one question to Professor Odote. Do you think it's mandatory that the CLE with other stakeholders that regulate the legal practice in Kenya establish mandatory courses for the practicing lawyers so that they can keep them up in match with the changing aspects in this world? And the other thing I want to respond to Mrs. Emily's questions. What are the biggest challenges that the legal profession in Kenya faces? One of the challenges is the political interference. We have the judiciary, the Attorney General, and the office of the ODPP that the political arena in Kenya plays a main role in ensuring who is in those offices, ensuring how the offices operate through the appointments. The appointments have to be approved by the parliament. The parliament is full of politicians. So the politics interference are really a main challenge in the legal profession. And I want to echo what Max has said. A lawyer in this era should have the technological skills, specifically in the artificial intelligence arena. Things are changing. Lawyers have to advance to the technological advancements. Thank you.
Okay, there's a hand at the back there.
Thank you. My name is Rebecca Wandera. I'm a student undergoing the Advocate Training Program here at the Kenya School of Law. And Professor Odote, you have mentioned that among the challenges facing the legal education in Kenya is that academic programs offered in university law schools are unable to keep up with the pace of development of other law-related disciplines. So my question to you is, in your opinion, do you think that the quote-unquote rapid accreditation of tertiary institutions to offer law as a course in their curriculum is a contributing factor to this, in that a good number of institutions offering law in undergraduate level are still at their what I would term virgin stage. They're still yet to offer the course over a long period of time, and as such are unable to have advanced or a level of innovation, a level of advancing the skills that they're offering. And drawing comparison from the medical profession, which just like law is a profession and both have bodies governing them, we see that the medical profession has managed to religiously guard the accreditation process of tertiary institutions which offer medicine as a course in the institutions. So what steps is the Council of Legal Education taking in order to ensure that this situation is remedied, in order to ensure that we have law schools having the capacity to keep up with the pace of law in this developing arena of technology, science, and innovation? Thank you.
All right, thank you, Rebecca. Well, I think we can request now our speakers to respond to those. I have a couple of them from our online participants. One, what is the place of ADR and AJS, alternative justice systems, in our curriculum? Two, how will technological advancement be incorporated into the legal education, for example, AI? Three, should CLE and KSL make changes so that there can be more training-oriented curriculum rather than exam-oriented curriculum? There is another one here. What is the prospect of allowing programs such as Juris Doctor, as is done in some countries, such as Australia, where holders of undergraduate degrees are allowed 3 years of law training? I think all these are policy issues. There is another one here. Is it feasible to include a technology-related course in the Kenyan legal curriculum? For instance, including a programming course would expose lawyers to issues surrounding IP in coding. Okay. The other one has something to do with academic progression from certificate, diploma to LLB and so on. So our speakers, please take the floor. I don't know who will go first. All right, all right.
Yeah, I think
please use the microphone. There was a microphone that was. What has happened? We can. Okay, you can speak from here. It's all right. Yeah. Okay.
Okay, I think for me, I'll just answer 2 or 3 questions, then I can give way to the professor to continue. For AI, I think this is something we must incorporate. In fact, it's not that we must, it's already here, and we'll be forced to incorporate it. So the challenge or the issue really is how do we do it? How do we ensure integrity? How do we ensure that it's used in a way that is beneficial, but it will not be exploited? Yeah, will not be exploited. So it's just a matter of sitting down, having conversations, and discussing on how we can put it. We've incorporated it already, but how we can use it to ensure integrity and no exploitation. And then the matter of the Office of the AG taking it in undergraduate law students. I think that is what you meant, undergraduate law students. We do take in undergraduate law students. In fact, I have 2 or 3 in my office. I've been having them in the last, I think, 10 years. I've get from Strathmore, from UON, and they work with us, and we really train them. And of course, we take the pupils. I think the Office of the AG is the largest pupillage center. And we not only take them, but we also ensure a few hold over. And when there's an advertisement for a vacancy, we give priority to our pupils, the pupils who trained under us. So we do take pupils, we do take interns for attachment from various universities. And they learn quite a bit actually, because they have to go through all the departments. And you know, the Office of the AG has, I think, almost 10 departments. You would go through litigation, you go through international law, you go through government transactions, Department of Justice, Advocates Complaints Commission, you do registrar of companies, you go to the registration of companies department, legislative drafting, so you really get a good idea of what happens in the world. And then there was a question on political interference, but I didn't really understand what you meant. Do you mean that the state officers are appointed in a way that is not right, so that it affects legal education? I didn't get to the question. Could you repeat it? Who?
Legal arenas, the judiciary, the office of the ODPP, the Attorney General, the legal class has a big say on will be in those arenas, and as we know, the majority in the political class have the say. Maybe the opinion of the minority class in the political arena wanted to propose their own, or wanted another person proposed instead of the person who was approved. But with the legal dean and the legal interests, the political interest of those in say will have a greater impact on who will get on those seats. Yes, so it's a great challenge, I think.
Yeah, I think that is true, because you find in most appointments, there has to be the appointing officer, there has to be the parliament has to whatever, and you can't get away with politics at that level. But in theory, really, we are supposed to, it has to be, there should be no political interference. They should appoint the best possible person to do the job. But I agree with you, but at some level, there must be that interference. I cannot deny, I'll not deny that. Yeah, but we hope that it doesn't really affect the quality of our services, the quality of our legal practitioners, so that we try and get the best that we can do. We can get. I think those are the three that I can respond to. I think the rest are more in your line, Professor.
Thank you very much for the questions. Let me start with a question from Max. The nexus between studies and setting of exams. And there are two answers. I think answer one is we can try and pass the buck between CLE and KSL, where the problem is. And that's a convenient issue. I will not do that. I think the more important thing is that it is important that what is taught and what is said speak much more to each other. And that's the place of the curriculum. Without a written, clear curriculum, you'll continue having that debate. If you saw what we put in as the first priority, and something that I even started before I came in, we are at a very advanced stage of having conversations about a written curriculum, so that this debate can into the future be had in a much more objective manner, and that we can be able to reduce the bus parking. We can be able to stop arguing about, is it Mwaniki who didn't teach the right thing, or is it Odote who didn't set the right thing? So that it is clear that this is the objectives, this is the outcome expected, these are the learning outcomes, this is the course content, and therefore, these are the kind of things. And you will find, if you have the honest debate, that the problems are at both levels. In certain instances, the people that set may set things that are outside what's been taught. In other instances, the people who teach may actually not teach what should be taught. But I think, as opposed to the debate about who is wrong, who is right, the more important thing that there's commitment from both of us is to ensure we have a clear, well-written curriculum that can be able to guide this process much more into the future. I think that's issue number one. Issue number two, should law be a second degree? That is from Ian, isn't it? I want the answer, Ian. That's my only response. I also want an answer. Should it be a second degree? What I know is that it is an important conversation that we must have and reach a decision. As Colin Sodote, I have an idea as to what I prefer. As the chair of the Council of Legal Education, I have no idea. I just know that that discussion must be had. Unfortunately, I can only speak as the chair of the Council of Legal Education. If I say anything, it will be said, CLE has said. We haven't. But we need to have that discussion. That's why I told you about the Future of Legal Education Conference. So that all these things we can discuss and reach a decision. Because there are pros and cons of both. There are those who say, no, actually law should be a second, so that you have a base. Others say, no, that's for them. For us, it's a first degree. Maybe I only have money, do 1 degree. How do you force me to have to? So I think it's important for us to look at context and have that debate and make that decision. Bill, and the question of Mwenda. The problem with both the approach of recognition of prior learning and the one about reducing entry requirements in the context which you've raised them is that they are then reactive as opposed to being proactive and futuristic. Because then we are reducing the debate to recognition of prior learning to that will allow Mwenda to be able to practice. Yet, in my view, if you look at that issue, there are two problems in that conversation. The first problem is, how do we regulate the profession and education effectively to ensure that those who eventually practice are those who are qualified? That problem, I don't think, will be solved only by recognition of prior learning, because even if you do so, there will still be the question about those who masquerade. Even the issue about reduction of grades. Even if you reduce, there'll be people who are below those grades, isn't it? So I think for me, both issues are legitimate, but they should be separated. We should separate the question about how do we regulate the profession much more effectively to ensure that those who get in and get out are the ones who are entitled to do what they do, vis-a-vis the very legitimate question that in a country where we even have a policy on recognition of prior learning that was passed by Cabinet early this year for the TVET sector, what does that mean for those who started from diploma Is it possible for them to progress, yes or no? And I think that's a conversation we need to have. Henry here continues to have the challenge about you're having a diploma, you've admitted these people, and after you've done so, they can't then be able to progress. All I can tell you from a regulatory point of view, the question about the different standards, the question about we have admitted, now we can't, from a regular point of view, and something we even discussed, I think, around 2 weeks ago, we are clear into our mind that moving into the future, we need to be much more responsive to clients, we need to be much more responsive to students, so that people know upfront, this is black, this is white. And we're going to be working with all the legal education providers to ensure that as part of the condition for licensing, we are making the appropriate communications at the start. Because a challenge not for one institution, it's a challenge for the entire sector. You get admitted, and they start from the challenge of the different laws. Someone will tell you, my law says this, my law says the other. I think we must look at the sector so that we are much more clearer to students and people know their options as they start. So that I know, yes, if I get admitted here, I can do law, but I can't be admitted as an advocate. Then I make the choice. Or if I do law here, I can be a paralegal, but I can't then eventually progress. Then I make the choice. That communication, I think, is something we owe and something that we are going to be working together with all the stakeholders to ensure it happens much more. That's a conversation we had just a few weeks ago. And that, I think, answers your question. Silas, should CLE establish mandatory courses? The last time I checked, the law actually has mandatory courses. There are 16 that every university must have, then you add on to the others. I think the more important question, and that I can guarantee you we are going to have, should those be the continuing 16 mandatory courses, number one. Number two, in light of the transition to CBC, should there actually be 16? This is the only place where I will speak as myself. Speaking as myself, and that's a question from online, I think in 2024, any bachelor's law curriculum must have a course on technology. And that answers that class. I think we can't run away from it. We must. So if I was asked about what we do about change, one of the things I would change is to make technology a mandatory course, because it is with us both for better and for worse. For those of us who teach, we continuously grapple with the place of AI. I know their colleagues even say, let us not do online exams because students copy. And I tell myself, I don't think that is the solution. I think it is us who must change what we test and how we test it. Because technology is not going away. We can say do things physically, but real life has moved to online. So we need to prepare our candidates. So for me, but that's myself. But it's just to tell you, Silas, that the debate about the mandatory courses is not whether we should have them, but what they should be and how many they should be. And it's a conversation I'm happy to have. Rebecca Wandera, you raise important points, but I think the basics may not be fully accurate. I don't think the problem is about rapid accreditation. I think the question must be about how we enhance quality. There are two approaches of doing this. One approach must be to say, we require fewer law schools. That must be one approach. And if you ask those who come from the first universities, if you are from where I teach at the university, they'll tell you, actually, we didn't need more. The University of Nairobi is enough, isn't it? And you'll go to the next one down the road, they say, no, let's not have more. The guys who are out say, let us have more. I think there are two things we must ask ourselves. The first thing we must ask ourselves, how many lawyers does the society need and for what? And have that objective conversation. But the second is, what's our approach to regulation? Is our approach to regulation preventing the numbers, or is our approach to regulation ensuring that the standards and the qualities are high? And that conversation must be a question about, I don't think it is fair to prejudge university that you think, because University X was licensed yesterday. I think at our last sitting, we were looking at renewal of licenses for several places. We were licensing KSL for their program. So if you now say, you know, those that we licensed last week should be the last. Let's not license anymore. Where's the gentleman from Nazarene? When were you licensed? Do you know? Not too long ago, isn't it? So if we took Rebecca's approach, you may not have gone to law school. So that's how we must look at it. Because then we'll be saying X should not be, and I think for me that's the wrong approach to regulation. I think the greater conversation must be, how do we ensure that we balance between quantity and quality and focus on, remember that the mandate of the Council of Legal Education is to ensure quality of legal education, not to prevent, not to restrict quantity. Because if we focus on quantity, people think when you fail exams, you will be told, you know, CLE is controlling the numbers. So they release the numbers as Panadol. So they say this year we only want 20 people to be lawyers, so we'll fail 180. I think a poor approach to regulation. Regulation must focus on quality as opposed to quantity. The place of ADR in AJS, I think the online issue and even technology, the point that they all make is that first, ADR is really recognized as a critical part of the curriculum. But I think what is critical is that a curriculum must continuously be refreshed, must continuously look at what is changing, and must continuously be able to be adaptable. And I think the ideas that you provide just demonstrates the importance of us being able to change. I think the last question is the one about academic progression. Again, something for us to deal with as part of the policy and as part of the continued discussions. But I think extremely, very, very useful suggestions, and just shows the urgency of us to be able to reach final decisions on some of those things quickly, so we can have predictability, we can have innovation, and we can have change. Thanks, Monique.
If Monique can allow me to also respond to a question, to comment, because I think it's touched on the school. The issue of admission criteria, which was raised at the front here. The school uses what's in the second schedule. So B in English or Swahili. There's no one who has been rejected because of having a B in Swahili. That is in the law, and we always accept. It's a C+, mean B in English or Swahili. That is what the Court of Appeal has confirmed. The issue of progression now, that is a big headache. And as Monique has said, it's meant that we've been the respondents in numerous lawsuits. So if you go back in history, you'll see that the previous regulations under which the school operated allowed for progression. Very clearly they're set out. But there was the issue of, let's say Uganda. People did not meet the requirements, went to Uganda, did LLB there, came back. And then the issue went to Parliament that we are starting to admit lawyers, advocates who did not qualify to join Kenyan universities for LLB. How did they resolve that? By putting now in law, in the Act, that you have to have that C+ and B in English or Swahili. Of course, 10 years later, we are seeing that may not have been the right approach, because there are quite a number of qualified people or people who should have an opportunity to go into the ATP who are locked out by having such a rigid criteria, which is now what the policy and changes will hopefully address. One, of course, solution they had put was to have that pre-bar. So maybe, again, policy, do we have a pre-bar so that whatever you have studied, if you can pass the pre-bar, then now you can do the ATP. But a lot will also come to that question, what is legal practice in Kenya? Is it just appearing in court, or doing all the other things that a lawyer can do without necessarily appearing in court? And also just a final comment on the issue of cross-border practice and education. I think that is going to be very critical, because the opportunities should not be restricted to Kenya for lawyers. We should be able to practice outside, but then issues of reciprocity come in, which I think is why, as we go to CBC, it'll be interesting to see how we frame our legal education so that we do not then lock out any possibilities of cross-border practice due to that issue of harmonization. There's a lot of work, a lot of thinking to be done ahead, and looking forward to that conference on the future of legal education. So back to the moderator. Thank you.
All right, thank you very much, our presenters, for responding to those questions, and thank you very much, Director, for clarifying that issue. I know, seated here, we cannot exhaust all the questions that probably in our minds and hearts about legal education and training. One big challenge, Prof. and Madam Chair, that you regulators will have to deal with is the transitional. So whatever we put in the policy and whatever they are doing in Parliament, if they are doing things in Parliament with a rear view mirror, so whatever policy decision is made must incorporate a transitional mechanism to deal with the hundreds, if not thousands, of people out there in limbo. What's the way forward about it? It's a big challenge. Thank you. Of course, something else that has been mooted in the past concerning East Africa might be a good idea to, even at an informal level, to do something like East African Bar Schools Association. And we can share ideas. You know, these days we don't have to travel to Kigali and Dar es Salaam. These days we can always share ideas virtually and so on. It might be a good idea. Now there was a request that we share the email address that we can use to communicate ideas to the Office of the Attorney General concerning the proposed policy on legal education and training. So I have an email address here. You can take it down, those present here and those online as well. Thomas, just Thomas, Thomas.Kibunja. Kibunja is Kibunja @ag.go.ke. So thomas.kibunja@ag.go.ke. On that email address, our comments, our views will be able to reach the Office of the Attorney General. All right. It's now time for us to take a short health break. I've been requested that we take a group photo just outside the main block there as we go for a cup of tea. So I request that we all, including our guests, we all take a quick photo there, then we have a cup of tea, then we come back here for our second session of the morning, which is still on legal education. And we request our guests this morning, Prof. and Mr. If your schedule allows, please stay on. We have two other people speaking on the same subject immediately after tea. So if your schedule allows, please stay on. Then you might get a few more ideas. Yes. And just before we leave, Director, we have a small gift pack for our two guests. I confirm that the value is not more than 20,000 shillings, so you don't have to declare it as required by the law. Thank you. So let's all go for the group photo, then a cup of tea. 15 minutes should be enough. And then we come back very quickly. There's a proposal that we adjust the program today a little bit, that instead of taking a lunch break, we do the 2 quick papers on legal education, and then we invite the speakers scheduled for the afternoon to present immediately after that, so that when we break off for lunch, we will not need to come back here. Is that a good proposal? Yes, I think it is. Asanteni sana.
The Kenya School of Law was established in 1963 when a total of 11 students were admitted. From its establishment till the early 2000s, the school was located on Valley Road at the current University of Nairobi's Dental School. The school was a department in the Attorney General's office until 1995, when it was removed from that office and placed under the management of the newly established Council of Legal Education.
And after this, this position remained until 2012, when, as a result of a task force that had been established in 2006, the school was delinked from the Council of Legal Education by virtue of the Kenya School of Law Act 2012 and the Legal Education Act of 2012. So the Kenya School of Law Act established the school as an independent institution, whereas the Legal Education Act established the council as an independent regulator of the legal education.
The new functions included training on legislative drafting, training of judicial officers, and organizing special short courses, amongst others.
So the units that are taught at the Advocates Training Program, they are 9 in number. They are statutory in that they are provided for under the law, and this includes civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, legal practice management, professional ethics, conveyancing, and commercial transaction.
At the Kenya School of Law, this is where the rubber meets the road, because the program is intense, the training is rigorous, and the time is short. Unlike campus whereby you have 4 years, at the Kenya School of Law you only have 9 months to do your classwork, and you have 6 months to work at a law firm or a legal institution. Therefore, with the Kenya School of Law, you are required to put into practice everything you've learned for the 4 years, and of course you come and also learn new things. Therefore, for someone who is aspiring to join the Kenya School of Law and to become an advocate, you need to be very well prepared. You need to be adversed with the courses that are being offered at your school, because those are the very same things that you're going to learn at the Kenya School of Law, and you're required to do that in a very short time.
The expanded mandate was not implemented until after 2006, when a task force chaired by Professor Githu Muigai recommended to the then Minister for Justice and Constitutional Affairs, Ms. Martha Karua, that the school needed to undertake continuing professional development and paralegal studies, in addition to its traditional functions.
Our other program is Diploma in Paralegal Studies, and that is aimed at preparing persons who will be support staff in the legal sector, whether in a law firm, in the courts, in private companies, and so on and so forth. So the Act sets out the admission criteria for both categories. For an advocate, you must have performed at a particular level in your KCSE, that is having a mean grade of C+ and a B in English or Swahili, and then done your undergraduate and come here to the school.
The school implements the core mandate through 2 divisions, the Academics Division and the Continuing Professional Development Research and Projects Division.
Kenya School of Law is a very interesting institution. The program is rigorous. The teaching is good, however. The lecturers are quite engaging, quite understanding, and they are ready to take students all the way up to the time when they sit for their council legal education examination. And not only do we learn how to become advocates, but we also learn how to develop character.
In KSL, it's very lenient. I knew little to no much about law, but then now coming out of KSL, I'd say I know so much. So I'd say my interaction here in KSL has been amazing.
The school has maintained ISO 9001-2015 certification because of its desire to maintain high standards of service delivery that satisfy the needs of the customer through continual improvement. All our processes and strategies are such that they all work toward the goal of excellence.
So the mandate of the school under Section 4 of the Act is to train persons to be advocates, to provide continuing professional development, to provide paralegal training. Fourthly is other specialized training, other specialized legal training. The fifth is develop curriculum and examinations. And lastly, to provide projects, research, and consultancies.
The Advocates Training Program, ATP, has the objective of training lawyers for entry into the legal profession. Training is conducted in 18 months, 12 months in-house, and 6 months pupillage or internship. Teaching in ATP is conducted on a clinical basis, practical for the purpose of equipping the learner with skills to practice law in the real-life situation. The classes are divided into firms, which are study groups where legal problems and issues are thoroughly discussed.
One of the topics that is usually taught in the ATP program, we have a unit called mooting. So students get to participate and have a feel of what to expect in practice. So moot court competition is basically a simulation of court, and then there is a winner. So students have actually traveled outside the country due to moot court competitions. So this is one of the great opportunities that we get to engage in.
For one to successfully complete ATP, one has to pass in all the 9 units: civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, professional ethics and practice, legal practice management, conveyancing, and commercial transactions.
We conduct 3 sets of exams for the PTP, that is termly because you have the 3 terms, but for the pre-bar it's only once a year, ordinarily in January of every year. In every academic institution, you would expect that there will be disciplinary issues. Most of them range from issues of pupillage, especially when students are on pupillage, that is what is the equivalent of attachment. You find that there could be some misconduct, maybe some student has left the station without notifying the master, or they may have carried themselves in a manner that does not befit the profession.
We engage learners at 2 different levels: full-time and part-time lecturer.
As a student, it's been very convenient and has allowed most of the people who are working to get an opportunity, because you see, in the evening we start classes around 5:30, so it's not going to affect my working time. So 5:30 to around 8:30, we are done with class, which is very convenient, and lecturers are very accommodating.
Part-time lecturers bring in a wealth of practice experience and practice which is key to teaching our ATP students. Our ATP students participate in legal aid in and out of Kenyan prisons. This helps the students to have a real scenario before even being admitted to the bar. The school has key linkages with other institutions, which include the Higher Education Loans Board, HELB, the Chartered Institute of Arbitrators, the Advocates Complaint Commission, and the Advocates Disciplinary Tribunal, to mention but a few.
The task force made recommendations on legal education, how to streamline legal education in the country. And among the recommendations which came out of that task force was that there should be a continuing professional program which would target working people lawyers and related disciplines who are working, and it's meant to build their skills in law, to further their skills.
Through the Department of Research and Projects, the division also undertakes research and consultancy projects. So far, the flagship consultancy that the division has undertaken since the year 2012 has been legal audit and compliance, and more recently, governance audit. Legal and governance audits are now an important exercise that address institutions' legal and governance risks and seek to mitigate or manage those risks in a most effective and efficient manner, mainly through institutionalizing continual preventive measures. The two types of audit are now required of every state corporation under the Mwongozo Code 2015. The Human Resource and Administrations Department plays a critical support role to ensure that the school's core mandate is achieved effectively and efficiently. Specifically, we ensure that the school has qualified staff deployed correctly.
Career progression instruments have enabled us to ensure that we have highly competent staff in all the departments and the sections.
In addition, we ensure that the requisite physical infrastructure is in place and well maintained.
The library comprises of print resources over 10,000, and we are having access to online resources through subscription under KLISC, that's Kenya Library Association. Those resources can be accessed through the Kenya School of Law website and through the library portal, which is on the website of the school.
I decided to join the Kenya School of Law to undertake the PTP program because growing as a child I wanted to be a lawyer, and my qualification only allowed me to join the PTP program, which is a foundation for the career progression towards the LLB and ultimately become a lawyer to advocate especially for human rights and the legal needs that the community are seeking for.
I've been among the lucky students to get an opportunity to intern at a law firm, and I've been able to apply the skills in which I've been taught in class, like for example in our unit of legal writing and drafting, I've been able to get the practical aspect of drafting basic documents at the law firm.
The aim of the program is to prepare students who become the middle cadre in the legal profession and the graduates of the program who are now known as paralegals can serve in law firms, in the judiciary, in NGOs and in companies, supporting lawyers working in those organizations.
The school is lucky to be located in a serene environment in Karen, which is not only conducive for learning, but also for other activities, especially in the hospitality industry. The school has excellent facilities for conferences, workshops, training, social events, available at very competitive rates. Our services include conferences, gardens, weddings, retreat, team building, accommodation, and a restaurant. We also have auxiliary services, swimming pool, hire of transport, laundry services, sauna, and sport facilities.
Under sports, we have several sports that are happening. We have mini golf, we have rugby, we have soccer, we have a basketball team.
I've actually participated in athletics and football. I've had a chance to win a silver in the long distance race.
The school prides in offering great services to all our stakeholders. Currently, the school has 2 campuses. Our main campus is located in Karen along Langata South Road, Nairobi, while our town campus is located within CBD along Moi Avenue, Development House, 5th floor. The Kenya School of Law was established in 1963 when a total of 11 students were admitted. From its establishment till the early 2000s, the school was located on Valley Road at the current University of Nairobi's Dental School. The school was a department in the Attorney General's office until 1995, when it was removed from that office and placed under the management of the newly established Council of Legal Education.
And after this, this position remained until 2012, when, as a result of a task force that had been established in 2006, the school was delinked from the Council of Legal Education by virtue of the Kenya School of Law Act 2012 and the Legal Education Act of 2012. So the Kenya School of Law Act established the school as an independent institution, whereas the Legal Education Act established the council as an independent regulator of the legal education.
The new functions included training on legislative drafting, training of judicial officers, and organizing special short courses, amongst others.
So the units that are taught at the Advocates Training Program, they are 9 in number. They are statutory in that they are provided for under the law, and this includes civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, legal practice management, professional ethics, conveyancing, and commercial transaction.
At the Kenya School of Law, this is where the rubber meets the road, because the program is intense, the training is rigorous, and the time is short. Unlike campus whereby you have 4 years, at the Kenya School of Law you only have 9 months to do your classwork, and you have 6 months to work at a law firm or a legal institution. Therefore, with the Kenya School of Law, you are required to put into practice everything you've learned for the 4 years, and of course you come and also learn new things. Therefore, for someone who is aspiring to join the Kenya School of Law and to become an advocate, you need to be very well prepared. You need to be adversed with the courses that are being offered at your school, because those are the very same things that you're going to learn at the Kenya School of Law, and you're required to do that in a very short time.
The expanded mandate was not implemented until after 2006, when a task force chaired by Professor Githu Muigai recommended to the then Minister for Justice and Constitutional Affairs, Ms. Martha Karua, that the school needed to undertake continuing professional development and paralegal studies, in addition to its traditional functions.
Our other program is Diploma in Paralegal Studies, and that is aimed at preparing persons who will be support staff in the legal sector, whether in a law firm, in the courts, in private companies, and so on and so forth. So the Act sets out the admission criteria for both categories. For an advocate, you must have performed at a particular level in your KCSE, that is having a mean grade of C+ and a B in English or Swahili, and then done your undergraduate and come here to the school.
The school implements the core mandate through 2 divisions, the Academics Division and the Continuing Professional Development Research and Projects Division.
Kenya School of Law is a very interesting institution. The program is rigorous. The teaching is good, however. The lecturers are quite engaging, quite understanding, and they are ready to take students all the way up to the time when they sit for their Council Legal Education examination. And not only do we learn how to become advocates, but we also learn how to develop character.
In KSL, it's very lenient. I knew little to know much about law, but then now coming out of KSL, I'd say I know so much. So I'd say my interaction here in KSL has been amazing.
The school has maintained ISO 9001-2015 certification because of its desire to maintain high standards of service delivery that satisfy the needs of the customer through continual improvement. All our processes and strategies are such that they all work toward the goal of excellence.
So the mandate of the school under Section 4 of the Act is to train persons to be advocates, to provide continuing professional development, to provide paralegal training. Fourthly is other specialized training, other specialized legal training. The fifth is curricula, develop curriculum and examinations. And lastly, to provide projects, research, and consultancies.
The Advocates Training Program, ATP, has the objective of training lawyers for entry into the legal profession. Training is conducted in 18 months, 12 months in-house, and 6 months pupillage or internship. Teaching in ATP is conducted on a clinical basis, practical for the purpose of equipping the learner with skills to practice law in the real-life situation. The classes are divided into firms, which are study groups where legal problems and issues are thoroughly discussed.
One of the topics that is usually taught in the ATP program, we have a unit called mooting. So students get to participate and have a feel of what to expect in practice. So moot court competition is basically a simulation of court, and then there is a winner. So students have actually traveled out of the country due to moot court competitions. So this is one of the great opportunities that we get to engage in.
For one to successfully complete ATP, one has to pass in all the 9 units: civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, professional ethics and practice, legal practice management, conveyancing, and commercial transactions.
We conduct 3 sets of exams for the PTP, that is termly because we have the 3 terms, but for the pre-bar it's only once a year, ordinarily in January of every year. In every academic institution, you would expect that there will be disciplinary issues. Most of them range from issues of pupillage, especially when students are on pupillage, that is what is the equivalent of attachment. You find that there could be some misconduct, maybe some student has left the station without notifying the master, or they may have carried themselves in a manner that does not befit the profession.
We engage learners at 2 different levels: full-time and part-time lecturer.
As a student, it's been very convenient and has allowed most of the people who are working to get an opportunity, because you see, in the evening we start classes around 5:30, so it's not going to affect my working time. So 5:30 to around 8:30, we are done with class, which is very convenient, and lecturers are very accommodating.
Part-time lecturers bring in a wealth of practice experience and practice, which is key to teaching our ATP students. Our ATP students participate in legal aid in and out of Kenyan prisons. This helps the students to have a real scenario before even being admitted to the bar. The school has key linkages with other institutions, which include the Higher Education Loans Board, HELB, the Chartered Institute of Arbitrators, the Advocates Complaint Commission, and the Advocates Disciplinary Tribunal, to mention but a few.
The task force made recommendations on legal education, how to streamline legal education in the country. And among the recommendations which came out of that task force was that there should be a continuing professional program which would target working people, lawyers and related disciplines who are working, and it's meant to build their skills in law, to further their skills.
Through the Department of Research and Projects, the division also undertakes research and consultancy projects. So far, the flagship consultancy that the division has undertaken since the year 2012 has been legal audit and compliance, and more recently, governance audit. Legal and governance audits are now an important exercise that address institutions' legal and governance risks and seek to mitigate or manage those risks in a most effective and efficient manner, mainly through institutionalizing continual preventive measures. The 2 types of audit are now required of every state corporation under the Mwongozo Code 2015. The Human Resource and Administrations Department plays a critical support role to to ensure that the school's core mandate is achieved effectively and efficiently. Specifically, we ensure that the school has qualified staff deployed correctly.
Career progression instruments have enabled us to ensure that we have highly competent staff in all the departments and the sections.
In addition, we ensure that the requisite physical infrastructure is in place and well maintained.
The library comprises of print resources over 10,000, and we are having access to online resources through subscription under KLISC, that's Kenya Library Association. Those resources can be accessed through the Kenya School of Law website and through the library portal, which is on the website of the school.
I decided to join the Kenya School of Law to undertake the PTP program because growing as a child, I wanted to be a lawyer, and my qualification only allowed me to join the PTP program, which is a foundation for the career progression towards the LLB and ultimately become a lawyer to advocate especially for human rights and the legal needs that the community are seeking for.
I've been among the lucky students to get an opportunity to intern at a law firm, and I've been able to apply the skills in which I've been taught in class, like for example in our unit of legal writing and drafting, I've been able to get the practical aspect of drafting basic documents at the law firm.
The aim of the program is to prepare students who become the middle cadre in the legal profession, and the graduates of the program, who are now known as paralegals, can serve in law firms, in the judiciary, in NGOs and in companies, supporting lawyers working in those organizations.
The school is lucky to be located in a serene environment in Karen, which is not only conducive for learning, but also for other activities, especially in the hospitality industry. The school has excellent facilities for conferences, workshops, training, social events, available at very competitive rates. Our services include conferences, gardens, weddings, retreat, team building, accommodation, and a restaurant. We also have auxiliary services, swimming pool, hire of transport, laundry services, sauna, and sport facilities.
Under sports, we have several sports that are happening. We have mini golf, we have rugby, we have soccer, we have a basketball team.
I've actually participated in athletics and football. I've had a chance to win a silver in the long distance race.
The school prides in offering great services to all our stakeholders. Currently, the school has 2 campuses. Our main campus is located in Karen along Langata South Road, Nairobi, while our town campus is located within CBD along Moi Avenue, Development House, 5th floor. The Kenya School of Law was established in 1963 when a total of 11 students were admitted. From its establishment till the early 2000s, the school was located on Valley Road at the current University of Nairobi's Dental School. The school was a department in the Attorney General's office until 1995, when it was removed from that office and placed under the management of the newly established Council of Legal Education.
And after this, this position remained until 2012, when, as a result of a task force that had been established in 2006, the school was delinked from the Council of Legal Education by virtue of the Kenya School of Law Act 2012 and the Legal Education Act of 2012. So the Kenya School of Law Act established the school as an independent institution, whereas the Legal Education Act established the council as an independent regulator of the legal education.
The new functions included training on legislative drafting, training of judicial officers, and organizing special short courses, amongst others.
So the units that are taught at the Advocates Training Program, they are 9 in number. They are statutory in that they are provided for under the law, and this includes civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, legal practice management, professional ethics, conveyancing, and commercial transaction.
At the Kenya School of Law, this is where the rubber meets the road because the program is intense, the training is rigorous, and the time is short. Unlike campus whereby you have 4 years, at the Kenya School of Law you only have 9 months to do your classwork, and you have 6 months to work at a law firm or a legal institution. Therefore, with the Kenya School of Law, you are required to put into practice everything you've learned for the 4 years, and of course you come and also learn new things. Therefore, for someone who is aspiring to join the Kenya School of Law and to become an advocate, you need to be very well prepared. You need to be adverse with the courses that are being offered at your school, because those are the very same things that you're going to learn at the Kenya School of Law, and you're required to do that in a very short time.
The expanded mandate was not implemented until after 2006, when a task force chaired by Professor Githu Muigai recommended to the then Minister for Justice and Constitutional Affairs, Ms. Martha Karua, that the school needed to undertake continuing professional development and paralegal studies, in addition to its traditional functions.
Our other program is Diploma in Paralegal Studies, and that is aimed at preparing persons who will be support staff in the legal sector, whether in a law firm, in the courts, in private companies, and so on and so forth. So the Act sets out the admission criteria.
Welcome to the second session of our conference, day 2. We are still in this session continuing with the sub-theme on legal education and training in Kenya. We have 2 speakers lined up, as you will see from your program. And without any further ado, I would like to invite the first speaker. On the program there, it says Care and Boru. They have co-authored a paper, the 2 of them, but the paper will be presented on their behalf by Mr. Peter Care, who is here with us. Mr. Care is an advocate of the High Court of Kenya. He is also an adjunct lecturer in the AATP program here at the Kenya School of Law. Mr. Care, karibu sana. We will allow you 15 minutes. All right, thank you.
Thank you very much, the organizers, for this good moment. It's always a pleasure to, if I can call it, back home. And the reason I'm calling it home, it's because I was in the inaugural class that was in the Kenya School of Law when it was brought here. That was sometimes in 2005. So I think that is among the reasons that we developed a passion about legal education, because I remember before we came here, we were really not impressed, because the group that was just 1 year ahead of us had actually been exempt from coming to the Kenya School of Law. So the paper I have co-authored with Mr. Goru, who is at the moment pursuing further studies at the New York University. Myself, I'm an alumni of Moi University, but I've done my LLM from the University of Nairobi. So straight into the point, I want to start by playing some clip of someone who you know very well. Is it audible?
Sisi wa engineer tunasema sisi ndio learned. Na tumesoma zaidi kushinda wakili. Kutengeneza gari ni ngumu zaidi kuliko kwenda kupiga kelele katika koti.
Okay, there's another one.
What is it that we are looking for?
Looking for something that is real. Get mine. The word learned friend was invented. It's a very particular category of intellectual Before you could study law, you learn philosophy, you learn anthropology, you learn geography, and then is when you are now allowed to go and study law. And therefore law was at the apex. Somebody was, and that's why they are called learned friends, because they had learned so many other professions. These days, somebody has also gone to university for 4 years and he called himself a learned friend. Just like people call themselves here doctor of medicine. In Germany, where I studied, you are only called a doctor if you've got a PhD. Somebody with just a first degree in medicine is just called a Facharzt. It's not a doctor. Because doctorate confers something higher. But here now he's a doctor, and you're just a mister. But those are subjects for another day.
Thank you very much. Now, I picked out 2 things from those 2 clips. The second one, it was played during the funeral of the late Justice Professor Odek. So you can be rest assured, the speaker there was very clear on who the audience was. He knew in that particular setting, we had so many advocates, or people who are calling themselves learned friends. Now, that is what informs our discussion. I'm looking at indisciplinarity in legal education, infiltration by the unlearned friends. So I'm doing it on behalf of Golo as well. So when I say I mean him as well. So the summary of what I want to talk about is this concept of a learned friend, like what exactly is it? Then we link it back to the legal training. Then we look at the legislative framework, then the landscape, the technological advancement, and the future. Then there'll be a conclusion. From the benefit of those who are here in the morning, I think most of these things have been covered, so I would not want to be the one to repeat them. So I'll go straight to what I want to say. Now, where did this learned friend thing come from? Is it because of the nobility of the profession? Is law considered a profession in the nobility? Is it any different from, say, a doctor who is also saving lives? Is it different from an engineer? Like, is it what stands out this profession from the other professions that exist? Is it the service that we render in the society? Because we have been trained that a lawyer is a social engineer. Is it the qualifications that we have? Again, we had part of that discussion. Should you just become a lawyer out of your own, maybe 1 degree, or is it something that you need to do over and above? So is it this training that we get that distinguishes us from other professions to call it, to be able to refer to ourselves as learned friends? Is it intellectual preparation? Is it any different from any other professions? Is it, again, is there a difference between someone who is learned and not educated? So can we say, for example, a doctor or an engineer is educated but is not learned? And then, does that mean then a lawyer is just learned but is not uneducated? So that is just a debate that was going through our head. Then the more important one is, when we use this term learned friend out here in the society, are we out to intimidate other people? Or are we out to motivate ourselves? But from what we are arguing, we find that this particular session, because whenever we say it, and you can see from the clips I played, I don't think it is being taken so kindly in the society. So perhaps that is the driving point, why it gets to motivate other people against us. So people will say, those ones who think they are learned, we need to show them how they are not. So that's how we looked at it, intimidator versus motivator. But again, is it enough to just have an LLB to be called learned, or do you need to first be an advocate, or is it both? So there are three main arguments here that we intended to make, and the first one is that people in other professions are actually becoming very confident to venture into the legal space. So you find that while we were there exclusively doing legal services, we now have various other professionals that they have comfortably, and actually they're edging the lawyers out of this profession. So again, this is what I'm trying to look at. Is it then using that traditional role as a lawyer, is it still viable in the modern society? Because as it is, we're actually diminishing in terms of our societal impact. Now, the best examples of how our space is diminishing is that now we have other professionals who have come into our space. I'm sure now if you're looking for procurement services, you are likely to find a procurement expert who is not a lawyer. The best example so far is the tax. Now, when we get tax matters, you find that most of them are actually done by the accountants. So that means, again, it is a space that has gone out, and it is no longer exclusive to the lawyers. There's technological advancement, and that one, again, I think most of the speakers have made reference to it, so I wouldn't want to overemphasize it. But again, we have a policy framework and statutes that continue to develop. And when they continue developing, they are now reducing the number of lawyers in the bodies. Because initially, it was an entitlement. You just knew whichever body is being brought up, it must have a lawyer. But as it is going, you realize that it is now having more people and less of the lawyers. And in fact, there's been that argument that the problems you are facing today stem from the lawyers, because the lawyers were at the forefront during the liberation to come up with the Constitution. So they say most of the problems are probably because of the lawyers. So again, this thing called learned friend, I don't think so far there's been any concerted effort to interrogate what it exactly means. But like I said, our profession is no longer exclusive. We have other people coming into our space. But unfortunately, as lawyers, we are becoming slow to venture into those other disciplines. So we are just there complaining how our space is reducing, but we are doing nothing to show why it should not reduce, like we are not protecting our space. So remember, a professor in the morning said, who moved our cheese? I think I would add another question there and say, where were we when the cheese was moving? So of course you have seen the commentary, but I just picked that one from the Right Honorable Raila, because I think he's the one who maybe most people are familiar with. So do we go back to our education system? Is it responsible for us being learned, or is it responsible for our diminishing prospects in the profession? Now, when you look at training, I think there are three main areas that training usually is focused on, and one of them is to produce academics, and those are people who lecture like us. Then you have practitioners. Of course, this concept of practitioning is becoming, again, very diluted, because we are no longer sure who is a practitioner. Is it someone who takes out a PC and then he can go and do online presence, or they can become a carpenter, like I saw we had in news, one of them who had become, I think, a coffee farmer or picking coffee. But assuming he has a PC, is he practicing? Okay, the other space is the policy formulators. So the elements of training, we usually have the theory, and that is the knowledge, the practical skills, and the general education of law. Remember, when a client walks in, he will not tell you, I'm coming under the law of succession, or I'm coming under the doctrine of maybe battered women syndrome or basic structure. He'll come and tell you his problem. So it is for you, the lawyer, who should be able to then put it in a way that you are becoming responsive to him. So I think that is the difference that we have with other professions, because if you went to an accountant, he will only know those specific, maybe the statutes that deal with tax. He may not relate them to maybe constitution, he may not relate it to contract or many other areas. He'll focus on that area of specialty. And that is why, for me, I think the objective for advocates training is not just to be legal practitioners, because I think that is what the focus seems to be now, but you need to bring out technicians, the legal technicians. These are the ones who can offer overall legal services. Then just statistically, as at now, I think we have slightly over 22,000 advocates. Our population is also about 55 million or about there, and we have about 7 law schools. So the question that comes out is, have we really reached that moment where we can call ourselves, now we are at mass production level? So have we become like other professionals where it is no longer exclusive, but is now up for the market? But when you compare to other countries like the UK or South Africa, you find that our ratio of lawyer to society is about 1 to 3,000, which when you compare to the UK, it's about 1 to 500. South Africa, it's about 1 to 2,200. Now, as part of the training, the issue that comes out very much is, now we have the Kenya School of Law, we have the CLE, and we have the law schools at the universities. Is these three distinctions, is it something that is still viable? Is it something that we need to go or look on it? Or is it something that maybe we don't need this distinction after all? Like you remember, again, the professor said, there is sometimes a mismatch between teaching and the exam. Again, from my limited experience from the lectures, sometimes when you get your curriculum or let me call it the course outline, there are so many things that you can talk about in any area. For example, if you're talking about commercial law and you're talking about electronic payment systems, you can go all the way. We can talk even about crypto, we can talk about blockchain, but we don't know what the examiner is going to teach, to set. So do you really want to waste students' time teaching them all those things that you think are relevant, but they're not going to set? And I know sometimes the students will tell you, is that going to come into our exams? So I don't know. I don't know what was coming in the exams. So I will just say mine is to impart knowledge. At least it falls within the curricula. Then there was that issue of the pre-bar and the direct entry to Kenya School. Is it something that was supposed to help anything? Or by the time you get to Kenya School of Law, it's already a done deal? Then you have an issue with the accreditation, and should the accreditation be done by the Senate of the universities? Should it be done by the CLE? Is it something that someone said? Nowadays, you get things through the court order. So if the court forces you to admit a student, so does it then matter what the accreditation is about? So those are questions, and my role here is to raise questions. I may not have the answers, so the answers are supposed to come here collectively. Back to the learned friend. As a lawyer, of course, you have to always go back to the law. Now, when you look at the Constitution, there are all those fundamental rights, right to belief, association, expression, all those things. So is it anything different if I refer to myself as a learned friend in the society? Or can someone in another profession then consider that to be discriminatory? Can someone say, why are you calling yourselves learned as if you are the only profession? There's always that form when you fill, and they ask you to fill your profession. So can someone, for example, the engineer, like Raila was saying, is he better placed to call himself learned if he's an engineer than a lawyer? So is it something that should really matter in terms of how we define it? Now, again, I think my theory is whenever we continue to call ourselves learned, we just motivate other people to cannibalize us. And that is how our space is shrinking. We are doing nothing about it. We are always going to react. And that is why I probably have a problem when our work as law society is to continue going after the people we are calling quacks. Because if there was a quack, it should be clearly distinguishable that this one is a quack from probably the services they offer as opposed to a lawyer. So if a member of the public cannot tell the difference, then who is the problem? Is it the quack or is it those of us in the profession? Of course, now we have a landscape that is changing, and mostly is technology. Now, we keep going against the quacks. But what about BRS? BRS is the company's registry. It has totally moved online. Again, that is an area that we lawyers were doing. We are no longer there. When you look at the court filing, it has all gone digital. So again, you can really practice from your seat. You can file, you can commission, you can upload, you can even apply for, you can be heard, you can extract your order, all from your seat. So can we then say even that is cannibalizing our profession? Now, of course, there's been that fight in the Lands Office about our disasa, which is also a technological advancement. So again, these are things. Look at immigration, look at tax, KRA. So lawyers who are doing all those things now can no longer do it because even people of the cyber cafe are doing much better in terms of that type of practice. And that is why I was not very sure when the members of the society were complaining about it. Again, where does that leave us? we have disruptions, we have so many areas that are emerging, and I think that is the advantage you have in the modern profession as opposed to the past. In fact, someone said when the 2010 Constitution was promulgated, it actually standardized all of us because none of us had read it, of course, apart from those who were involved, and interpreting it was so wide, it was so many areas that were coming up, and now it is only for us to be motivated, and probably economically, or because of unemployment, for us to realize that then we need to do something for us to survive. So that is a difference between now the profession as it is presently and how it was in the past. So where does this leave our legal education? There is a whole argument that do we continue teaching homogeneously? Remember, the professor said we have about 16 courses that are mandatory for everyone. What if I want to just study law and then go and do online videos and get my following and be an influencer? Do I really need to study all those things? Is there a way I can just be specialized so that I'm studying the only thing that I'm interested in? Because at some point, there's a likelihood that you know what you want to do with your legal education. Personally, maybe I have no interest whatsoever to do any criminal litigation. Do I have to study criminal things? Similarly, there's someone whose passion maybe is just the Constitution. Does he have to study commercial law, for example? I don't know. That's a debate. And I'm thinking, since you are moving to 22,000 and the number is growing, and you're also having so many emerging areas, perhaps we need to reconsider how to re-engineer the training just to fit into specialized needs. But again, just like 844, there are those who are saying, just teach them. You never know where the bread and butter will come from. So you just learn everything. You will deal with it in future when the profession starts to take an inclination. Then what about the practical training? Is it different? Because you see, there's that Swahili saying where they say, kwa ground, between tofauti. So you find that most of us have the knowledge, we have the theory, but now when you encounter a live situation, you find that most of us are unable to handle it. Then should we then look at the market-driven training? Should we start and see the market and see what does the market call for? Who does it want in terms of legal services? Then we re-engineer our training so that we work backwards. Because you can easily train people, then they end up not being very useful in the market after all. And I think you have heard that about other professions as well, where you find that employers are really struggling to get people who can actually fit into the job market. So I'm sure law is not left behind. I think I've already mentioned that discussion about whether we need law schools and again Kenya School, and whether we need Kenya School and CLE as different entities, or we need to merge them, or maybe do away with them altogether, or do we need to devolve them? So that is a debate that goes all the way to the policy, and I'm sure at the opportune time, maybe we'll be called upon and we shall express our views, because I know maybe some of us have fairly strong views on some of these items. Then what about the training models? Should we sit in a lecture like this and be told? Should we maybe have a round table? Should we be taught from the court? If it's about litigation, should we go and learn from KRA itself? Like, should we be learning in a centralized place like this? Should we be taught virtual? Should it be taught physically? Maybe I need to be walking around instead of standing here. Maybe I just need to not even refer to anything, speak off head, so that I'm giving you most of the practical examples. So do you want to be taught by a theorist? Do you want to be taught by a practical person? Do you want a mix of both? So those are all discussions that are there, which will then be able to help us to know whether we are looking at the practical, we are looking at the specialized, or are we looking at the market-driven. Then, of course, there is integration of law and other professions, and my fear is the lawyers are the ones who are afraid of venturing into other professions. Other professions are actually venturing into the law, and they are succeeding so far. Now, if you are looking for advisory on matters that relate to probably mergers, transactions, and audits and all that, you are likely to find that an auditing firm will actually mount a more serious bid than a law firm. And they may even get it. Now it brings into the question, when you, as an advocate, you are part of that team that is an advocate that bids for this particular work, where does that leave you as a member of the profession? Shall we call you in-house? Shall we call you sharing with an unqualified person? What is it? Is it bread and butter so that we don't matter, everyone to hustle their way out? That is a discussion that I'm just bringing out of it. Then that obviously brings us to the adequacy of the curriculum. Is the curriculum that we have able to deal with all of these things? Should it then be amended? Should we have a revolving curricula? Should the curricula be developed upwards and then collected downwards? Or should it be, should the people who are actually intending to study be the ones to come up with the curriculum? Because maybe during the first class, you can ask people that now you want to join the legal profession. What do you think? How do you want to join it? Because unfortunately, now we are dealing with a generation that I can call it is a bit unique in its own way, in the sense that the way maybe they're handling their issues is a way some of us can never even have imagined. So you find that in the profession, we have two types of people. There are those who will be opening their mouths in shock and wondering, hey, is this where we are heading? And there's another one who will be saying, you guys, since you're not moving with the time, I don't say go to hell, but something along those lines. So basically, I think because of the time, I did not go into the history of the legal profession because you had so many committees. You had the one for Denning, we had the one for Kiumi, we had the one for Justice Quach, and we had the one for Professor Githu Muigai, the ministerial committee, and I think that is the one that made us come to law school in 05. And there's the other one for Fredo Jambo, which I'm not sure they have implemented, but it's, I think, the latest one. So I think with that, maybe just in terms of conclusion, I'll be looking at it as, do we still think the issue of being called learned friend should arise? And for now, my view is, I think it is not a priority. We have bigger problems to deal with as opposed to reference. This is a wake-up call. There's a whole infiltration of the legal space. And for those who are following the LSK elections, you found that most of the presidential contenders, they really had something to say about this. Everyone was saying our space is shrinking. Another one was saying we are being infiltrated. So it is something that we are seeing, and it is noticeable. So it is how we deal with it that is going to define what we become in future. But what I cannot run away from, in my own view, is I think we need to consider really hard the cross-professional training, because our profession does not really exist in a vacuum, and only the innovative ones, like using Charles Darwin's theory of evolution, only the innovative ones are going to survive. Otherwise, we'll perish, and we'll probably be saying, we used to have a legal profession, then we'll be reminiscing with the senior members of the bar. Thank you very much, and I'll be happy to take questions.
All right, thank you very much, Mr. Kerr. We will take one more paper. This is the last paper on the issue of legal education, and then we can have a quick plenary session concerning Mr. Kerr's presentation and the one by Ian Morut. Ian, please come and give us your paper, Legal Education in Kenya. We will allow you 15 minutes. Karibu sana.
Good afternoon. Now, I remember very well in class 7, my social studies teacher gave us an exam, and we did so poorly that he refused to release the results to us for reasons well known to him. And strangely enough, after the class, he called me out and he said these words to me: I would one day like to see you seated somewhere as a big judge. Now, back then, many things were happening. One of them was the Raila one, the first presidential election petition in 2013. And I remember I sat there on TV, and I saw the judges, and I thought to myself that they were very good at their craft. And right then, I knew I needed to get the best education to be like them, the best legal education. And in my assessment of that legal education, my paper covered 4 key areas: the state and challenges of legal education in Kenya, the need for reforms, where I gave rationales, and I also examined accreditation as a key concept when it comes to quality assurance in the legal education sector. And on the final part, I took a wider lens and looked at the effectiveness of 2 bodies, one, the Advocates Complaints Commission and the Disciplinary Tribunal, in carrying out the mandate of ensuring professional standards in the legal profession. And to cap it off, I examined continuing professional development, the CPD, as a mechanism for progressive qualification in the legal profession. So I'm going to make my presentation very short by dint of the fact that the first 2 parts have been well covered by my previous presenters, starting with Professor Odote. And maybe just to go to our key recommendations on how legal education can be improved. And one of the recommendations, as even the professor was saying in the morning, was resource allocation in the legal education sector. And I took a keynote in the use of taxpayer money, and which is the main theme of the conference. And as we all know, education is a socio-economic right as per Article 43. And ensuring that enough is provided for this legal education to take place will connote a satisfied social contract, in the sense that the society needs well-trained lawyers, as it is the lawyers that are tasked with the force of engineering the society to fit the needs therein. Also, I looked at political will in the face of political changes, policy changes, sorry. And as even the good professor was saying in the morning, the issue of proliferation, where we see, he was talking about the debate of quantity versus quality, with the increase in the number of law schools, increase in the number of admissions into law schools. And I took a key concern with the ATP program. And as we've seen, one of the policy changes in the Legal Education Amendment Bill of 2022, Clause 2 therein of the proposed amendment seeks to allow accreditation of other legal education providers to license the advocates training program. Now, I had a problem in my paper because this issue raised with the issue of proliferation will see to it that monitoring still will become a problem. But that view has since changed after going through the Council's strategic plan for the 2022-2028 year period. And one of the strategic responses therein was that they termed this move by the legislators as a threat. And one of the responses therein was, instead of this liberalization, what should happen then is decentralization, where we will have the Kenya School of Law offering ATP programs in other areas in other regional areas of the country. And that made more sense because monitoring then will become easy because it is one institution offering the same ATP program across the country as opposed to many institutions offering the program. So that was a key change after going through the strategic plan. The next part I tackled quality assurance in legal education, and some of the tools therein, as we've seen. And my key take was the legal education, accreditation, and quality assurance regulations, which I shall therein refer to as Legal Notice 15 of 2016, which speaks more on accreditation of legal education providers. And just to give a narrative of how accreditation happens, the regulations start in Regulation 2 by defining what accreditation is. And accreditation simply is the issuance of a certificate by the council to a provider of legal education by the fact that it has met the standards that have been set by the council itself. And in ensuring this quality assurance, Regulation 4.3 of the regulations dictate that when applying for accreditation, the legal education provider must submit a feasibility analysis of the curriculum, emphasizing the rationale behind the program, including its unique area of focus. Going further, Regulation 5.1 states that this applicant, the legal education provider, if it fulfills the criteria as set in Regulation 4.3, the council will then proceed to inspect the premises and to verify whether it meets the requirements as set by the Legal Education Act. Going further, Regulation 5.4, that if the council decides that accreditation is warranted to the legal education provider, it will grant the license for a validity period of 5 years. And going forth, Regulation 6.1 prescribes that the council must, from time to time, conduct quality audit of the legal education provided by the legal education provider from a period of, let's say, 2 to 3 years after the accreditation of the said institution. Regulation 6.2 speaks on an investigation that it can either independently or on request inspect the legal education provider to see if it still adheres to the accreditation terms. And Regulation 6.3 of the regulations speaks on the renewal of application, as the good professor was saying in the morning, which is a key aspect, that in a bid to see to it that quality is assured, renewal of the license of the said legal education provider must be done, and the said provider must apply for the same 1 year before the expiration. So what we see here is one of the approaches that the council takes in assuring quality in the legal education sector, and it is the standard-based approach. However, this approach faces many issues, and many of the challenges come as a result of the internal deficiency of these accredited institutions. And most of them were said in the morning by one, Ms. Chair, who is present, and also the good professor. Poor student assessment, where they brought the issues of online examination, the issue of poor reading habits, which can be linked to deficiency in reading materials, let's say the libraries, and what I like to term as commercially acquired grades. And also we've seen this throughout, that most students will pay for their term papers to be written for them, etc., etc. So one of the measures I came across is the other approach of ensuring quality in the legal education, termed fitness for purpose approach. Fitness for purpose approach now goes the other side, that it is now the role of these institutions to live by their mandate and philosophy, that while taking heed to the needs of the society, they should ensure that the internal quality assurance mechanisms bid to curb institutional challenges, as we have seen above. The other thing, which was also echoed very well in the morning, is that of curriculum development. And we've seen what Lord Denning's committee did in 1960, that it will be better off if the legal education provided in the country suits the specific needs as those that are in those local areas. And next, I looked at professional standards, and I capped this on Principle 12 of the UN Basic Principle for the Role of Lawyers, that lawyers shall at all times maintain honor and dignity of their profession as essential agents of administration of justice. And maintaining professional standards goes a long way in seeing to it that trust is also maintained in the legal profession, which also transcends the legal system of a particular state. And in ensuring these professional standards, I looked at two bodies, one, the Advocates Complaints Commission, and I'm happy that I have audience from the Office of the AG, because it falls within their mandate. And in examining its effectiveness, one of the issues that arose was a lack of independence in the commission. And I shall speak on two issues. One is that it is wholly funded by the Office of the AG through the President, and also the appointment of the Commissioner of the Commission is solely done by the President. And as a recommendation for that, there was a Stobbs report by Mark Stobbs, and he was saying that this should be fixed in that, yes, the commissioner is to be appointed by the president, but on recommendations from bodies such as the LSK, the JSC, and also the parliament. The other issue that affects the effectiveness of the commission was the duplicity of its roles with the disciplinary tribunal. And looking at the Advocates Act in section 53(4) and 61, it mandates the commission, also the tribunal respectively, to receive and consider complaints. Now what this does, it sees to it that both bodies are left with a very wide interpretation of their mandate, which breeds confusion in the nature in which they're supposed to carry out their mandate. The other issue was lack of proper procedure and rules in running the commission. And as it is enshrined in the Advocates Act, section 54(3), it is the Attorney General that is concerned with the structure and operations of the commission. And it mandates him to do this, which he did. I believe it was Amos Wako back then, that he came up with the Advocates Complaints Commission structure and procedure rules in 2003. But however, these rules did not show how the commission was supposed to conduct its mandate. So the issue that arises from these 2 points is that with the powers to determine its own procedures, the commissioners is left with an open avenue for abuse of power, which sees to it that the safeguards of natural justice are thrown out the window. The other issue was lack of representation of the Law Society of Kenya, and particularly in the disciplinary tribunal. As we all know, the LSK is mandated to look at the welfare of advocates, and it is key that such bodies have such representation so that the welfare of advocates therein can also be looked upon to. Finally, I looked at progressive qualification, where I looked at continuing professional development. And continuing the CPD goes in the line of, it involves the organized process of maintaining and enhancing knowledge, skills, and competencies, as well as fostering ongoing learning, pursued by individuals throughout their careers. Now, CPD in the legal profession in our country is governed by Legal Notice 43 of 2014, the Advocates Continuing Professional Development Regulations. And it has been made to the lot of backlash recently. And in the course of my research, I came across 4 factors. One is the advocate's dissatisfaction. So how does this come in? You'd see to it that advocates complain of high training costs, which come with registration fees into the programs, the manner of the delivery in which the teachings are done, and the most contentious part was the requirement tying the renewal of annual practicing certificates to the attainment of the said CPD points. The other issue was the advocate's instrumental approach to the program. What does this say? That advocates will simply attend CPD programs not for their progressive qualification through learning, but just because they want to get those CPD points with an eye of renewing the certificates at the end of the year. The other issue was advocate specialization tendencies. In recent practice, as it has also been echoed by my previous presenters, advocates tend to specialize in niche areas of law, and what might be taught in CPD seminars may appear to be irrelevant to them. And the last issue was that the program does not recognize learning gained through experience of years. This comes in by the fact that advocates that have been in practice for a long time are required to get the same points as those that have just been admitted into the practice. However, with such backlash, fortunately or unfortunately, CPD is here to stay, and there is case law on the same. And I would refer to you to the case of Eunice Nganga and another versus Law Society of Kenya and another 2019 EKLR, where the petitioner moved the court in a petition stating that the requirement to be a member of the Law Society of Kenya and that the CPD courses being a prerequisite for getting the annual practicing certificates violated her fundamental freedoms of association. The court, however, dismissed the petition by stating that the law keeps changing, so our practice matters. Members of professional bodies such as those of the first respondent, the Law Society of Kenya, that is, must keep themselves abreast with new developments in the law and practice. That the only way they can do so is through regular training. Attending programs initiated and developed by the society for their benefit cannot be deemed unconstitutional. This is because the programs are meant to enhance members' knowledge and skills, that if the petitioner's argument was to carry the day, it will render the profession moribund in terms of enhancing knowledge and skills. So, because the CPD, as the courts have said, is here to stay, what should be the approach? And in a bid to make it as effective, I focused more on the specialization tendencies of advocates. For instance, let's say there's a seminar on space law. I'm not a fan of space law. Will I attend the seminar? No, I wouldn't. But if I know that by attending the seminar I would acquire my annual practicing certificate, then I will attend for that purpose only. By the end of the year, yes, I'll have my practicing certificate, but that does not transcend to my progressive qualification in the profession. So, through the course of my research, I identified self-study, which has been limited by Rule 610 of the Legal Notice 43 of 2014. And as I was also going through the 2022-2028 strategic plan, one of the moves proposed there to strengthen continuing professional development by the school was to diversify those CPD programs. And that then marries perfectly with my argument that broadening the scope of Rule 610 of Legal Notice 43 of 2014 will see to it that there is a benefit in enhancing specialization and mastery of those niche areas of practice. And this will be an implication of progressive qualification in the long run. My name is Onoi Ian Emorut. I'm a lawyer and an advocate trainee at the Kenya School of Law, and that has been my presentation. Thank you.
All right, thank you very much, Ian, for that presentation. And so we will take some questions from the participants, those who are present here physically, as well as those who are attending virtually. So let's have one person to move the mic around. So please raise your hand if you'd like to pose a question or even to make a comment, and you can indicate whether your question is directed to Ian Emorut or Peter Kerr. There's a hand at the back there. Those attending the conference virtually, you are also welcome to post your questions in the chat. We'll read them and request the speakers to respond to them. And comments are welcome as well. Remember, we are still generating raw material for the proposed legal education policy. Please proceed.
Good afternoon. I'm Mark Lawrence Otieno from Class A. I have a question to both presenters. It can successfully be answered by the two. In the first presentation, it was noted that lawyers are being knocked out in their craft by other professionals. So out of experience, is it appropriate to streamline the curriculum to fit into the new societal needs, or is it appropriate to promote cross-dependence between the two or other professions in the law? Thank you.
All right, thank you, Otieno. So do we structure our curriculum so as to exclude, quote, everybody else from getting in? Good question. All right, there's a hand up down here.
Good afternoon. Ndungu is my name, an advocate of the High Court. My question is to both speakers. For example, if we had CPD points that are directed to specific specialities, for example, one on criminal law, the next one on law of the sea, would that be a solution to just attending CPD programs just for the sake of the points? Might that be a solution so that we have specific programs for specific specialities so that we avoid attending that which you don't even require, but you require the points, so you have to attend for the sake of attending?
Okay, thank you, Mr. Nungu. Sam?
Yes, I'm Sam Akwale, a lecturer at Kenya School of Law. I appreciate the presenters for making time to research, prepare, and present. I just want to raise my reflection with Mr. Kerr regarding the perceived invasion of lawyers' turf. And I'll use parallels from other professions. So we have the easy things for a lawyer to do, filing a running down case, registering a company, and so on. But maybe we thought that is what a lawyer is supposed to do. But maybe these were just the small things we had to do. But really, the lawyer is supposed to apply his or her lawyer's brain. The first parallel I'll draw is from the aviation industry, the pilots. I'm told the developments in aviation are such that pilots do very little once the plane is in the air. And even with the drone technology, probably it will be possible to fly a plane from down here. But I remember an incident when we had a plane from South Africa, which it's claimed that one of the wheels, the set of wheels dropped, and that pilot managed to land it safely at Jomo Kenyatta International Airport. And the passengers didn't even realize until after the incident. So that is the real test of his piloting skills. So it might be a test which comes once in a lifetime, but that is the real test. Some of us maybe go for routine checks with the doctor, either for yourself or your children, and you even feel cheated. You say, this doctor just looked at me, put a stethoscope on my chest, and gotten 5,000 consultation. But wait until that child or yourself, you're caught in a car crash, and then that doctor within minutes or an hour is able to arrest the bleeding, is able to rescue your spleen. That is the real test of being a doctor. So I think the challenge to us lawyers is what will set you an age above the routine things? What will set you an age above the clerk or the cybercafe owner or above the CPA who is doing an audit? My colleague here, Isaac Kuloba, and I think Naserian, and my other colleague, Lupao, we do legal compliance audits. But you might realize the way a lawyer approaches an audit is different from the way an accountant approaches it. There are times we are able to be carrying out the routine audit, but we are able to see through that there's a problem here, that the underlying problem in this organization could be financial management, it could be the HR practices and so on. And we don't assume that the accountant will have the same critical eye. So I think we shouldn't get into a fight with the other professions, but we should consider critically how can we set ourselves an edge above the rest so that people still come to the lawyers for solutions. Thank you.
All right, thank you so much. Okay, one more back there. Okay.
I think it's afternoon. Good afternoon.
Good afternoon.
Okay, thank you very much for the presentations, and it was very enlightening. And I really loved the part when they said that the lawyers were in our comfort zone, so we don't get into other professions, while the other professions are venturing into the legal profession. Then I wanted to ask, when a medic ventures into the legal profession, doesn't he then become a lawyer? So should there really be a difference between myself and a medic who is now a lawyer? I think, and I agree with the speaker who said that we should, as lawyers, think outside the box. We should think about doing something that always makes us faint, something like maths. We should be mathematical. We should think about maybe doing a bit of chemistry, because even for you to be called a learned friend, at the end of the day, when you're in court, you need to know about the chemistry. You need to know about the maths for you to be able to be a lawyer of straw. So I agree entirely that it's time that lawyers left their comfort zone of just knowing law and venturing more into other professions. Thank you very much.
Thank you, Mr. Chef, for that comment. Yep. Please bring the mic down here, Mrs. Chair.
Yes, thank you. Good afternoon, everybody, again.
Good afternoon.
Yeah, now I just want to contribute to two issues, not really ask a question, just to maybe inform. I want to contribute on the matter of the number of lawyers in Kenya. I think we've been told there are 22,000, about 22,000. Against a public of 55 million. That's what we've been told, I think. And I just want to say that in Kenya, although this number of lawyers looks a bit high, but in Kenya, a large majority of the country is not served by lawyers. In fact, lawyers concentrate so much in the main urban areas, and then the rest of the country remains completely unserved. This is a huge challenge that we've had, especially knowing that the AG is in charge of the National Legal Aid Service and the board, which is supposed to provide free legal aid, legal services across the country. So we even pay lawyers to provide these services. But when you go down to the ground, to the rural areas, you find you can't get lawyers to help you. We try to get paralegals, but sometimes it's even difficult. So you'll find, like, for example, Marsabit is served by Meru. Can you imagine the distance between those two? So Marsabit, Lamu, up there, Samburu, you know, in fact, there are hardly any lawyers at all to serve. And it's unfortunate because the courts have tried to decentralize, to go down to the ground, come up with various courts all across the country. The AG's office is now decentralizing and going all across the country. So I just want to urge the advocates, the lawyers also, to try and set up their offices in those areas. Maybe it might not be so lucrative, but I feel going forward, we should try to do that at least to ensure access to justice. Secondly, with regard to the Advocates Complaints Commission, I just would like everyone here to know that the Task Force on Legal Sector Reforms came up with an Advocates Bill, which is totally overhauling the original Advocates Act. So it would be very good for all of you to look at it and give your comments and see whether you agree or you don't before it's passed. I know the LSK has posted advertisements on public participation. I'm not sure if every one of you has received, but look at it and come up with your comments, because they are seeking to delink the Advocates Complaints Commission from the office of the AG, so that it's a standalone, it becomes a parastatal, meaning that it'll have more independence, it'll have a direct budget straight from Treasury, will not have to rely on the AG, which will really, really improve its work and its responsibilities. Yeah, so those are my two issues. Thank you.
All right, thank you. Thank you very much. I would now like to invite the speakers to respond to those questions. There's one from the online audience. How does the legal profession ensure that members are not selfish? And how can the general public benefit? I think from the profession. So I don't know if that's Mr. Kerr or Mr. Imrud. Any of you can deal with that. Now, something else, Mr. Kerr, you can comment on, because your paper is raising important issues for the future and so on. Earlier in the morning today, we talked about CBC. CBC is on the way to the university now. The last 844 class is in Form 1 this year. So in the next 3 years, we will have completed the 844 pupils. They will be at the university. Now what will happen, CBC is talking of pathways, 3 pathways, STEM, humanities, and then sports and the arts. So is there a suggestion there that the only people who will end up in the legal profession will come from the humanities pathway? Have we shut the doors for the guys from STEM, the guys from the arts? These are difficult issues. Mr. Kerr, please, come and respond.
Thank you very much for the questions. Sometimes this is an act of God. They say you are responsible for how much you eat, but not for how much God gives you upwards. Starting from what Mr. Mwaniki has raised, which is interesting, I feel that maybe it's about innovation at the same time, because like she said from behind there, if a medical doctor becomes a lawyer, then he is a lawyer. So I'm thinking all those people from STEM or humanities or sports and arts will actually still find space in the legal profession. That is why we have we have advocates whose purely their practice is on managing the athletes, managing the entertainment, because now there's a whole industry called the creatives, and it's really doing well economically, that people are now confident of saying, I'm an artist or I'm a creative. Because I know from maybe where I came from, if I was to dare say such things in the presence of my people, first I'll earn a smack on the spot, and secondly, I'll be told not to ever entertain such thoughts again. But now it is a profession. So I think as lawyers, and personally for someone like myself, I'm into the IP space, and most of the things you're doing really are for the creatives. And those are people in sports and in arts. So I think we can still specialize. So if we still things like climate maybe have an element of the STEM, we'll have lawyers who will do those things. And the other aspect that comes in is we have a whole, and among the reasons why lawyers are considered learned, it's because they are able to cross-examine anyone in court. That starts from even the doctor, the mechanic, the pilot, all of them. When they come before court, a lawyer should be able to cross-examine them in a manner that will actually be out. And so that means a lawyer should actually fit anywhere. Now, back to the other questions. I think starting with the curricula, personally, I feel it has to be cross-dependent. And I had said, the law does not exist in a vacuum. So if we want to stay where we were, we'll just stay and we'll diminish and diminish and diminish until, like I said, we'll be reminiscing about the good old days. You see, those days, we even knew we knew each other. When you go for a CPD, you could virtually identify everyone who was in that CPD. But nowadays, you go there, you don't even remember who, you don't even know. In fact, you become so excited if you can actually identify someone that you already know. So to me, I think that is something we have to deal with it. We cannot continue looking at ourselves in a comfort zone. So whether we want to make law multidisciplinary or we incorporate that aspect of it, then to me, I think that is a decision that will be taken after the policy comes out. But one thing I know for sure is that if we remain in our comfort zone, we are not going to get out of it successfully. Now, when it comes to the issue of specialization, I think, and the CPDs that is, there is an attempt, I see from the Law Society of Kenya, to have CPDs that cut across various areas of specialization. But again, the challenge is, sometimes it's about the timing, sometimes it's about availability, sometimes it is the quality of the presentation. So I think we are usually caught up. There are those who want that training at the point of information or introductory. And there are those who are looking for, like they're already advanced. So when you bring an introductory session to someone who wants to advance, then they feel it is relevant or it's taking them behind. Similarly, when you bring a more sophisticated presentation to people who just want to have the basics, then again, there's a mismatch. And then when you bring all of them towards the end of the year, most of us are in there for the points. So we'll just, and now it is even virtual, so it's very easy. All I need to do is log in. I can log in, continue working, then sometimes they put a query there or a question whether people should, I don't know, do what, some survey. Then that's when you realize, oh, it's still on. Sometimes if they don't do that, in fact, they'll log you out themselves after it's over. You'll not even realize that it was going on. So we go in it purely for the points. And not just for the points, for that, but for economic reasons, because I have paid my 2,500. Surely I must earn it. So I log in, because I'll feel first I paid, and secondly, I have to do this. So you find that towards the end of the year, most of us will just log into whichever is available, because we are trying to tick that checkbox very quickly. Now, in terms of, again, the other professions coming into to our legal space, I think I agree with some. I think as lawyers, we need to be at another level. We should leave this basic level, and that's why, using my own example, if I tell someone I'm practicing commercial law, I'm definitely not talking about incorporating companies, because I think that one, we surely must have moved from that. So you're looking at how to now commercialize, or they are fighting with maybe they're doing seed raising, they're doing the investments. So you have to come in at that advisory level. Incorporation, forget it. Similarly, when I'm doing IP, I've moved away from registering trademarks because that is very routine. You don't even need to be a lawyer, not even a paralegal. You can even just walk in, and most of these government services, they have people who can actually help you to get the service. So you don't really need to be in the legal profession. But now when someone has to monetize it, that is when now the law comes in, because that one, not even the AI machine will do it. And that is the advantage you have, that yes, we have AI that is also coming up, but there are some aspects that a lawyer will still be there. including even to feed that AI so that it can be responsive to the professional needs. In terms of, again, this venturing into other professions, and whether we need to get another degree or not, I think I will leave it at the point of if we are able to cross-examine people in the other professions, what is it that gives us that ability to be able to cross-examine people? Because we represent our clients who come from various fields. In fact, we hardly have our own lawyers as clients. So maybe, but that one I don't want to say conclusively, that law needs to be a second degree. But maybe, that's a debate. Again, in terms of our numbers, yes, while we have 22,000, again, most of them are not even active. So you'll find that the active number is somewhere between maybe 12, 13,000. And that's why I was even asking initially, what then is this practice and being active? I may be working very hard in a government body somewhere that I don't necessarily need my PC. So does that make me less of a lawyer? Does that make me not practice law? So you see, that is a challenge you're having because not all type of legal services require you to have a PC for purposes of being active in the LSK portal. And in fact, the best irony that I find is that the person who admits advocates, that's the Chief Justice, I suspect the last time I checked, she was inactive. So you can imagine how that looks like. Secondly, our advocate number one is the Attorney General, inactive. Look at the DPP, inactive. So when you are going for your admission, you are surrounded by these inactive people who are ushering you into the active practice. So I don't know, but like I said, mine is to just raise issues that I've seen. The debate will continue from there. But I agree with what Madam Chua is saying. You find that even those who go to court, from the statistics that came out, we find that only 19% of people go to court, which means we don't have 19% problems. We have about 100% problems. So where do these other people go? How are they helped? Because the fact that someone didn't go to court doesn't mean he didn't have a legal solution or did not seek for justice. And that's why from the judiciary perspective, I see they have been very active in promoting AJS, that's the alternative justice system, as well as embracing ADR, which has the mediation, which is now court annexed, and all those other mechanisms. Because then you realize that when it comes to court, maybe people are not even following what is happening, and that is why they don't see the need to come to court. And they think that when you come to court, sometimes it's a formality, and they're just coming in to go through the process. So I think she raised a very important question, and perhaps as professionals, we need to be very, very keen on where there is a need so that we can go and fill that need. So it's just not about the numbers, but even how the numbers are responsive to what the society needs. Now, in terms of that argument about selfishness, it's very tricky because for those who are outside, they always feel that those ones who are inside are gatekeeping and they don't want them to join. And similarly, maybe for some reason, those who are inside are also not keen to have everyone who is outside to join. So sometimes it feels like maybe joining the profession is a membership, like a club of some sort, where the person inside is always against the one from outside. And I remember from my undergrad studies, we had some exchange program students who had come from Nigeria. And he was telling us that in Nigeria, that was then, I don't know about now, but he said they had a quota system. So they would say, in this particular year, we are looking at 100 advocates. So of all the universities that are there, you'll be given your slot. Maybe they'll say, Nairobi, give us 20, Moi, give us 10, Nazarene, give us 5, Riara, give us 5, like that. So if, as a university, you want to recruit 1 million people, that's on you. But as long as, at the end of the day, your quota is 20. So how you get to that 20, that is your problem internally. So I don't know whether that is also a system that can be looked at. But personally, I feel there is space for all of us in this profession, and especially if you know how to carve yourself in terms of a niche. Similarly, we have the REM order that is supposed to regulate how we charge or how we bill the members of the public. So that, in a way, was supposed to bar selfishness. And I think at some point, even the Competition Authority was trying to regulate how the legal services are rendered to the society. But again, especially the private practice part of it, it's really very, very difficult to come and regulate because It's the same problem you're having about pupillage and how they should be remunerated, and the young lawyers and how to remunerate them. So if I have a law firm, for example, and I have no obligation whatsoever to take anyone as a pupil or as an advocate. So if I take them on my uncompetitive terms, and someone accepts and they have to do it, is it again on me to make sure that I'm competitive, yet it is a free market? Because again, the easiest alternative is to say, therefore, let me not take. So there's that argument. We do rather have money and give a little, but to more people, or give a lot of money to one person to do the task. So that is a socialism versus capitalism type of discussion that, again, I think is still up there for discussion. And I think finally, just to mention a few other things, is as part of the profession, we also need to be aware of the cost so that we don't make it look like it is an economic activity. Using my own experience, in the university, we had to pay, is it 100,000 for the whole 4 years? Our fee was barely 20,000 per year. So for 4 years, you've paid by about 80,000. And out of it, HELB was giving you the bulk of it. Because I think when I started, our HELB was 20,000 per year. So eventually, if I was to use what I used from the pocket, it's barely 30 or 40,000. But immediately you come to the ATP program, now you have to raise, that time it was 45. I'm sure now it's about 300. 1 million. Oh, 140, yes, 145, but that is purely minus the related, because all of us had to migrate from the village to come and study somewhere near the Kenya school. So when you look at the expense, you are spending almost triple in a span of 2 years. For us, it was 6 months. But now you have to raise more than triple what you spend over the whole 4 years. So for us, then it felt like maybe being a peasant is part of you not joining the profession. But if that was to be the case, then again, who are we targeting in this profession in terms of offering services to the public? So there's always that element. So we find that I have people that I know who could not raise that money at that point. And whenever they kept deferring to look for the money, the fees kept increasing. So eventually they were unable to get until so many, many years later. And that, from where I was, it is not something that was very desirable. So I find that people genuinely did not fear the study, but they are being cut out by other reasons. So for me, that is an area that maybe we need to look at it again. And now there's a proposal in Parliament, I think, where they want to lower even the bar further for joining the profession. I see from our LSK side, I think there's been some opposition to that, at least from what I'm seeing on social media. And I don't know whether that serves any purpose for now, but not. But since we just came from Lent the other day, and I'm a religious person, maybe it's good to borrow from the Bible a bit. There's a time Jesus asked his disciples. They went out there and I asked them, what do people say I am? So they came, they said, you are the prophet, you are the one who was to come, you are the Messiah. But then he asked a very important follow-up question. And he said, but you, yourselves, who do you think I am? So, of course, for those who read the Bible, they know what the answer was. But what I'm just trying to say is that as a profession, maybe we still need a moment to look at other people other than those in the profession to just tell us what they think about us. So we may be thinking that you are here, like that other example of if you have not eaten anywhere, you think that your mom is the best cook. Because I know when it comes to feeling good about ourselves, that one we are very good at. But we don't know what the rest of the society thinks. Remember I said you are 22,000. So what do 54 million point something think about us? Maybe they have a totally different view of what we think of ourselves. And perhaps we need to understand from that concept that once we know what other people think of us, then we can use it with what we think of ourselves insofar as we want to improve the profession, and especially in the future. Thank you very much.
Ian, is there something you'd like to add? Okay, fine. All right. I think we can end that session on that note. But of course, that doesn't mean that that's the end of the debate. The debate continues, and it is our hope and prayer that in the coming days, we'll have some concrete, answers, solutions to some of these challenges moving forward. Of course, the consolation is that in society, change must always happen. And when change happens, to tweak things a little bit to move with the times. Okay, so thank you very much, our speakers, Peter and Ian. I'm sure we will be sharing the papers with the participants, and they'll be able to read the more detailed write-up. Asanteni sana. Let's clap for them. Now, we had an agreement earlier in the morning, you remember, that instead of taking a lunch break at this juncture, and then today being Friday, we listened to the two remaining speakers now. Of course, we can stand up to stretch a bit so that we don't get deep vein thrombosis. As they come here, we stretch a bit and then we listen to them. And latest 2 o'clock, we close the session and go for lunch and call it a day. I think that's a good suggestion, isn't it? Okay. Right. So we can stand up and stretch a little bit as we invite our speakers that we had scheduled for the afternoon. So we go back to the main theme of our conference this year, which is about taxation. So our speakers, please come to the front here as we set up the systems here. Mr. Lupao. Mr. Lupao, we are looking for you.
The Kenya School of Law was established in 1963 when a total of 11 students were admitted. From its establishment till the early 2000s, the school was located on Valley Road at the current University of Nairobi's Dental School. The school was a department in the Attorney General's office until 1995, when it was removed from that office and placed under the management of the newly established Council of Legal Education.
And after this, this position remained until 2012, when, as a result of a task force that had been established in 2006, the school was delinked from the Council of Legal Education by virtue of the Kenya School of Law Act 2012 and the Legal Education Act of 2012. So the Kenya School of Law Act established the school as an independent institution, whereas the Legal Education Act established the council as an independent regulator of the legal education.
The new functions included training on legislative drafting, training of judicial officers, and organizing special short courses, amongst others.
So the units that are taught at the Advocates Training Program, they are 9 in number. They are statutory in that they are provided for under the law, and this includes civil litigation, criminal litigation, probate and administration, legal writing and drafting, trial advocacy, legal practice management, professional ethics, conveyancing, and commercial transaction.
At the Kenya School of Law, this is where the rubber meets the road, because the program is intense, the training is rigorous, and the time is short. Unlike campus whereby you have 4 years, at the Kenya School of Law you only have 9 months to do your classwork, and you have 6 months to work at a law firm or a legal institution. Therefore, with the Kenya School of Law, you're required to put into practice everything you've learned for the 4 years. And of course, you come and also learn new things. Therefore, for someone who is aspiring to join the Kenya School of Law and to become an advocate, you need to be very well prepared. You need to be adversed with the courses that are being offered at your school, because those are the very same things that you're going to learn at the Kenya School of Law, and you're required to do that in a very short time.
The expanded mandate was not implemented until after 2006, when a task force chaired by Professor Githu Muigai recommended to the then Minister for Justice and Constitutional Affairs, Ms. Martha Karua, that the school needed to undertake continuing professional development and paralegal studies, in addition to its traditional functions.
Our other program is Diploma in Paralegal Studies, and that is aimed at preparing persons who will be support staff in the legal sector, whether in a law firm, in the courts, in private companies, and so on and so forth. So the Act sets out the admission criteria for both categories. For an advocate, you must have performed at a particular level in your KCSE, that is having a mean grade of C+ and a B in English or Swahili, and then done your undergraduate and come here to the school.
The school implements the core mandate through 2 divisions, the Academics Division and the Continuing Professional Development Research and Projects Division.
Kenya School of Law is a very interesting institution. The program is rigorous. The teaching is good, however. The lecturers are quite engaging, quite understanding, and they are ready to take students all the way up to the time when they sit for their council legal education examination. And not only do we learn how to become advocates.
I'd like to invite our first speaker, Mr. Buruki. The paper was authored by 2 persons. One of the authors is not here yet, but the co-author is ready to present the paper. It's entitled Taxation Tsunami, an analysis of implications of enhanced taxation policies in sovereign debt management on socio-economic rights. So let's all welcome Mr. Buruki.
Okay, good afternoon. My name is Buruki Silas, a final year student at the African Nazarene University. I co-authored this paper with Mrs. Juliana Giridi, the chair, African Nazarene Law School, and the moot coordinator at the African Nazarene. We titled our paper Taxation Tsunami, an analysis of the implication of enhanced taxation policies in sovereign debt management on social economic rights. Basically, taxes are the primary financiers of the government expenditures, and with the old dean of fiscal deficits, that's where the debts step in. So our paper basically examined on the link between taxation, debt management, and the social economic rights. Secondly, the potential consequences for individuals' access to basic needs as a result of the enhanced taxation policies, and we conclude the paper by offering several recommendations. So our introduction, we basically viewed a brief history of how Kenya found itself in the, the whole edge of the cliff on tax matters. We not sleep and wake up in a single day and find ourselves that we are in a debt crisis. It was a process. It was a process that has been happening since independence. And we really attribute the whole thing of the debt crisis from the moment that Kenya attained independence, with a lot of things to prioritize in development. We had the roads, hospitals, water supply to prioritize. And the government had
inherited scattered economic or the uncoordinated set of taxes from the colonial government, which could not really finance the budgetary means in finances. So the government had to resort to borrowing. And by the end of President Moi's tenure, the government had borrowed a total of Kenya shillings 629 billion, which was about 60% of the total GDP. Later, we see President Kibaki in 2004 launching the Constituency Development Fund in order to prioritize the social economic rights. But later in 2008, he launched the Vision 2030 plan, which at a step I could say was a retrogressive measure in the progressive realization of the social economic rights. Reason being that the Vision 2030 plan had big plans that the Treasury could not finance. So the government would resort to borrowing. President Uhuru's regime, 2013, and a lot of big plans, huge plans for Kenya, SGR, actualization of the LAPSET program. The government had no money to finance all these projects, so it resorted to borrowing. By 2017, the total debt rose to 3.9 trillion. And with the COVID-19 pandemic in 2020, 2021, by March 2021, the total debt had shot to 7.3 trillion. And as by February of this year, the debt shot to 10.09 trillion, leading to adoption of enhanced taxation policies. One of the things that were adopted is the doubling of the tax on petroleum products from 8% to 16%, and the introduction of new tax burdens in the pay-as-you-earn. They introduced new tax burdens. So those are some of the enhanced taxation policies that the government has adopted in attempt to mitigate the debt crisis. So basically, a lot of things, in how the social economic rights have been enshrined in our legal instruments, the Constitution, and the international covenants on social economic rights was discussed yesterday. So I will not really repeat that because of the essence of time. So I will jump to the Kenya's mandate in advancing the progressive realization of the social economic rights. So states are the primary duty holders of the human rights under the international law, and courtesy of Article 2.1 of the Constitution, of the ICSR, the International Covenant on Economic and Social Cultural Rights, Kenya is obligated to progressively realize the rights provided for in the covenant. And what does progressive realization entails? When we say progressive realization, what does it mean? One, we mean that the state must continuously improve the conditions, and two, the state have the obligation to withhold from taking deliberate retrogressive measures, except under specific circumstances. For instance, the state should not just evict people. That will be a retrogressive step towards achievement of the right to affordable housing or adequate housing, unless under specific circumstances. And let me draw attention to some things that happen now that we have the rains. Like you saw the flooding along the banks of Madare River. So such circumstances, the state can decide to evict people from the banks of Madare River in one thing to preserve life. That's when the state are allowed to retrogress a little from achievement of the social economic rights, but they must take a step to ensure that the right that they are denying or the right that they are retrogressing against, they take a step to ensure that the right is still attained by maybe providing compensation for the people that they kick out of the banks of Madare River. So the state are an obligation to ensure that there is progressive realization of such right. So how debt servicing has influenced taxation policies. I'll quickly jump to that. Okay, the Kenya post-independence economic strategy was focused on, financing the domestic project through loans, with the assumption that the economy will grow, and with the economy growing, the export trade will eventually grow, and we'll have a lot in our foreign reserves to, help in repayment of the public debt. But these things have really not been true, or they have not actualized. One, because of two reasons: unforeseen economic factors such as the oil crisis, pandemic, the COVID-19, the 2008 economic depression. Such economic factors have really affected how the state has been able to, the economy has been able to grow or actualize the goals that they had when financing such projects. And number two, poor planning. A good example is the Isiolo International Airport. The airport was constructed at a cost, was upgraded to an international airport status at a cost of around Kenya shillings 1 billion. It was expected to handle around 6,000 passengers a week and tons of cargo. To today, Isiolo Airport handles less than 3 small planes per week, no cargo. So that's how serious the things are when there is poor planning. On 12 December 2023, President Ruto stated without explanation that his government needed to curtail spending and halt implementation of vital development programs in order to stabilize the economy. It is the president who says so, that the government and to curtail or to cut budget in some sectors so that they can try and stabilize the economy. And without justifying, and justifying the increment on the taxes introduced by the Financial Act 2023-2024, the doubling of tax on petroleum products from 8% to 16%, introduction of new tax bans, pay tax bans, he said that there is every reason to believe that without sacrifices and hard work over the past year, the crisis, threats, and challenges in the global economic and geopolitical environment confronting us would have overwhelmed us, as indeed it has many countries. He gave examples of Zambia and Ghana. And he further stated that together, we have made the right choices, sometimes taking very difficult and painful decisions to steer Kenya back from the edge of the catastrophic cliff of debt crisis and move our nation in a new direction. So what it was generally trying to mean is that we have every reason that as Kenyans, to accept suffering for a while, with the high taxes, so that we can at least try to save our country from the debt crisis that we are heading to. So, additionally, middle-income economies face a lot of, economic hardship. Citizens pressure the government. Oh, we cannot buy, we cannot afford buying food, unga, a lot of things. So the government has to step in and subsidize this consumption. The first quarter of the financial year 2022-2023, Kenya spent a total of Kenya shillings 43 billion on subsidizing maize flour, fuel, electricity, and fertilizer. Much of this was in form of loans from the International Monetary Fund, subsidizing consumption instead of production. When you subsidize consumption, they lead to a dead end. When you subsidize production, they facilitate the continuance of the cycle. We produce, we sell, we repay the loan, you see? So the government really spent a lot in form of loans in subsidizing consumption that lead to a dead end. So the burden is to shift to the taxpayers. We have consumed the loans. So how do we pay the loans? The taxpayers. Later, we viewed at a comparative analysis of how the government has been spending on debt servicing and the social economic spending. And we provided the financial year 2021-2023, the government spent Kenya shillings 917 billion in debt servicing. And on the other hand, it spent Kenya shillings 316 billion only on social sectors. Financial year 2022-2023, the debt expenditure was increased by 30% to Kenya shillings 1.2 trillion. And on the other hand, social economic spending, it reduced by 23.06%. Financial year 2023-2024 that ends on June, the government is expecting to have spent around Kenya shillings 1.6 trillion in debt servicing. It is the position of this paper. The expenditure on social economic spending will continue to lower. All these principles, yesterday, if you're in the conference yesterday, people really emphasized on the principles that the government should observe when trying to formulate their taxation policies. So I will just proceed to the next slide to avoid repetition. What are the consequences of the enhanced taxation policies on realization of social economic rights? Some of these consequences are directly linked, are direct, and the others are indirect. One of the consequences is disproportionate tax burden. Increase in taxes disproportionately affect lower income individuals. This affects the individual's ability to, to assess the basic needs. And there is a publication by the Business Daily on that March 2024. It exposed the Treasury's plan to revise the pay-as-you-earn on grounds that the structure had hit the low-income earners very early that they had a little to save and save. So that's how adoption of these enhanced taxation policies has affected those low-income earners. They cannot afford buying food. They cannot afford, renting decent houses. Number two, reduce disposable income. What is disposable income? It is the amount of money that taxpayers have to spend after deduction of taxes. So with high taxes, you have little remaining to spend. Meaning, you will cut your food budget, you will cut your housing budget. The next consequence, insufficient budgetary allocation to social economic spending by the government. Social and economic rights are institution-based, thus require mobilization of resources by the government for setup. The government taxes people a lot, then uses a larger percentage of the money, of the revenue they generate through taxing to pay the sovereign debt, meaning that the institutions that are there to advance the progressive realization of the social economic rights have little allocated to them. Programs like the Inua Jamii Senior Citizens Program, where our senior citizens receive a monthly stipend of around 4,000 or 5,000, they become affected. And sometimes when you visit the banks, you'll see these people coming to check where there's something, and they'll be told that the government this month has paid you nothing. You have nothing. So they have to wait for 3 months or 5 months so that the government at least can get some revenue, to provide them to acquire the basic needs. The other effect is increased tax non-compliance. Generally, not everybody loves paying taxes. Not everybody loves paying taxes. Yeah. So when taxes are increased, people are afraid, or companies are, that we are making less. So they will start driving ways to evade tax, avoid tax. So non-compliance will increase, hence the government will make less. The government will be able to raise less from the revenues because people have started evading tax to avoid, at least to maximize what they put in their pockets. So with government raising less, of course it will curtail the budgetary in the realization of the social economic rights. And lastly, it impaired investments. Investments Excessive taxation discourages both domestic and foreign investment, limiting capital available for the development projects. With no foreign investments in Kenya, with no local investments coming to Kenya, the government will raise little revenue from, the fees and the taxes that they acquire from these companies that invest in Kenya. So the government will still lack money to finance the realization of of socio-economic rights. And there's the case of John Kabui, Moi, and 3 others versus the National Examination Council and others. The High Court noted that one of the obstacles to realization of socio-economic rights is limited financial resources on the part of the government. So if the government has no money, realization of socio-economic rights will just become a dream. So I will quickly rush to making the conclusion and the recommendations. So social economic rights are essential to human well-being. They are the rights, housing, education. Those are the things that we need in our current world. So the paper wishes to make the following 4 recommendations. One of the recommendations is that the government should broaden the tax base by focusing on untapped revenue instead of burdening taxpayers. A quick thing, it's a funny one. There are less than 10 million registered taxpayers on iTax, KRA. But during our election 2022, the IEBC registered more than 20 million registered voters, meaning that adults, 18 years and above, they show the potential that lies there. A lot of people there are not paying taxes. KRA need to focus on those people. Address tax evasion. According to KRA, a report by KRA, Tax Matters, I think it was their magazine in 2021-2022, they said approximately Kenya shillings 259 billion is lost annually through evasion. Instead of burdening taxpayers with a lot of taxes, address tax evasion, you'll save 259 billion. Invest in export trades. The foreign exchange is very important in repayment of debts. So the government should try and strengthen the export processing zone so that it will try and load their foreign reserves that will aid in payment of debts. And finally, address corruption. It's something that everybody has seen. And I recall President Uhuru Kenyatta in 2021, in one of the public addresses, saying that the government loses 2 billion daily in corruption. Address corruption. Saving 2 billion daily, Kenya will be heaven. Education will have quality education. Hospitals will, have all the benefits that we need. People will not be going to India. So addressing corruption, it's something that people have overemphasized, and I will overemphasize too now. The government to address corruption instead of burdening taxpayers with a lot of taxes, and we'll progressively realize our social economic rights. Thank you.
All right, thank you very much, Cyrus. So we'll take both papers, and then we can have a brief plenary session. So now I would like to invite Chalo Wanyangu. Chalo, karibu.
Distinguished participants, ladies and gentlemen, good afternoon. Thank you. Where I'll pick up from, I remember Mr. Moniki just told us a few minutes ago to stand up. So I would wish to give him this small assignment just to tell us, when we are here at the school, where does the sun rise from? Like, maybe you can just point it. Someone volunteer? This direction. Okay, I'm volunteering 1 minute of my presentation time to take us through a very small activity. And in this activity, I'll request all of us to rise on our feet. Then, we want to, would you kindly please just rise for a minute? And we want to take this time to learn how to get direction from where we are standing without using our phones and without using a compass. So we will turn to the right, we'll let the right side of our hand face where the sun rises. So we will turn towards, we say the sun rises from this direction, so we will turn to this direction the way I've done. Then, effectively, if this is our east, then this becomes our west, then this becomes our north, and this is south. So this is our true north from where we are today. Thank you very much. Have a seat. So why did I bring that up? I brought that up because it's been in the flash disk. In the flash, yes. It has my name. Okay, so as we set up the slides, the reason why I asked us to find our true north is this, that since yesterday and today we've had conversations, and these conversations, there's one thing that has really been mentioned, which is public participation. And I invite you all to assist me answer this question, whether indeed public participation is our true north towards answering the questions in our discussions emanating from yesterday and today. My name is Charlo Wanyangu. I'm a paralegal in training here at the school, and welcome to my presentation. So my paper is entitled Public Participation in Public Debt, Enhancing Value from Kenya's External Loan. And in so doing, while I was writing my paper, I came across the words of this great philosopher, John Locke, who said that whenever law ends, tyranny begins. And now I zoom this into the context of public participation. So in addressing public participation, I anchored my work on a theory called the political business cycle theory. And this theory, why this theory? It assists us understand the political behavior that surrounds the whole decision-making and policy implementation process. And the theory, just to point out one thing, that public expenditures usually tend to increase during election periods. And we also see that because politicians are at the front of this, they also tend to manipulate market forces to their own advantage, which most of the time also succumb, they tend to work around and avoid public participation, and in most of the time, it leads us to, situations where we have to have these conversations on what we need to fix. So, and those studies began as early as 1959, where in 1959, a study by an author called Sharp emphasized that when debt is used to finance public expenditure, its real cost to society is a sacrifice in the private sector production and the wider reach gap. And narrowing down to Kenya, in 2018, we had a study by BET who established that even though our country has a comprehensive legal framework that governs public borrowing, there is an extensive lack of external borrowing, public participation, which leads to increased chances of misuse of public funds when they're not made available to the common citizen to give in their input. And similar trends in other developing economies have been observed in Nigeria and in Pakistan, as the respective studies allude in 2012 and 2008. Now, when we narrow down in the Kenyan context, I just tried to highlight, though this had majorly been covered throughout yesterday and even partly today. And the first place in our constitution where public participation is mentioned in Article 10 is at Article 10. Further, at Article 43, we see the rights, the socio-economic rights. And at Article 118, emphasizes on the role of public participation in the context of Parliament. So I highlighted the other laws that relate to that. Then I went further to identify institutions and organizations in the public borrowing discourse in Kenya. And here I separated them into two. So we have frontline organizations, which are the most active, that on a continuous basis, we usually hear conversations around them and decisions made by these organizations in regards to public debt. And this is the Parliament, the Cabinet, and the National Treasury, the control of budget, and the Auditor General. So this one I'll just quite try to rush through because a lot had been said through yesterday and about this. So the second bit of the organizations that I identified are the guarding organizations. First, I identified two organizations, one being the judiciary, that the judiciary would assist us with interpretation of the laws relating to external public debt and pronouncements on external public debt to ensure that borrowing and budgets advances the attainment on social and economic rights. The challenge that I would have for us in this room is, for example, when we are having conversations around raising the public debt, which Parliament does effectively, my question is to us, how effective is public participation in all that process, and how much have we approached the courts to answer this question? The second organization identifies the Kenya National Commission on Human Rights and Equality, that in playing its role in, as required under the Constitution, it also has a major role to assist us as citizens find the nexus between public debt, being external or domestic debt, and how that, again, translates to the whole socio-economic rights and taxation discourse and public debt. So my last question there would be, how do we work together to strengthen our guarding institutions? I proceed in the paper to also try to understand the advantages of public participation and why is it essential that we need public participation in these processes. Is that public participation, and as the earlier speaker just highlighted to us, and even following through presentations yesterday, one thing comes up, the matter of corruption. How are we addressing corruption? I submit that we can address corruption if we effectively integrate public participation. Why? Because with public participation, we have better transparency. And with better transparency comes better accountability, hence cost reduction, and there is a disincentive to citizens to participate in corrupt activities. Further, that public participation, if effectively done, can be able to guarantee us correct accounting procedures, because now of that earlier concept we mentioned on accountability, and therefore, in the long run, it guarantees us effective decision-making, both on a political and a policy perspective. My paper equally highlighted the challenges of public participation, specifically in the context of public external debt and in the context of taxation, that there is limited transparency, which generally impedes meaningful citizen contribution. This happens in that we find decisions are made in the boardroom, then they're passed down just for, let me use this word, formality, just to ensure that, yes, we have met the minimum requirements of public participation, so we took this out to the people. But in real sense, there is minimum transparency, and this is a challenge. Second, matters of finance are naturally a bit complex because, say, the numbers, the mathematics formulas, and all that. And a simple illustration I can give is, yesterday, Dr. Mulu in his presentation told us that Parliament does indeed publish reports related to these matters we're addressing in this conference. It is true indeed, they do publish, and even the Treasury publishes. But when we are going through this material, we will find that maybe we in this room can be able to a good extent to interpret and understand that, the context of that material. But I would assure us that when we go deep down to the grassroots levels, many people don't have the ability to understand this information, this kind of information. And therefore, that in itself renders them very least meaningful participants in the process. And that is something that we should reflect and see how we can address it. Lastly is a matter of weak institutional capacity and inadequate resource allocation in matters of public participation. So that said, we can agree that Kenya has made, as a country, we've made adequate steps towards creating a culture of public participation and inclusivity. And even as of this month of April, Parliament is in the process of developing legislation on public participation. My question to all of us today would be, deep down in your hearts and in your mind, do you believe that there has been effective public participation in the Public Participation Bill of 2024? Well, so then we proceed, as I head towards the tail end of my presentation, on the practical recommendations for effective public participation to ensure that we can enhance value from our public debt. First, I recommend that we recognize external public borrowing as a matter directly affecting the people's realization of their social and economic rights, and hence, it deserves mandatory public participation, and that has to be enhanced in the process. Two, we have an opportunity to define it in law, the minimum adequate time through which public participation should be conducted in order for its threshold to be considered effective. Also, we have the opportunity to have a requirement in the law that whenever Parliament conducts public participation on matters of external public debt, at least half of the counties, or other county assemblies, must be engaged. Also, inputs from public research institutions, such as the Kenya School of Law, other higher learning institutions, we need to put it in a way that they have to be engaged meaningfully in the public participation discourse, particularly affecting such complex matters. Because remember earlier, I did mention to us one challenge we face in terms of engaging people in public participation is that sometimes they don't comprehend these matters. But we agree indeed that in research institutions, in public institutions of higher learning, we have experts whom we can engage and seek their opinions and integrate their views on these critical matters. Another recommendation is on utilization of technology, that if we utilize technology effectively, including what was mentioned in the morning session on artificial intelligence and possibly virtual environments, we can bridge the inclusion gap and bring more people on board, whereby, yes, we can conduct virtual public participation sessions, we can have public repository areas where we can have this material availed for the benefit of the public. That seeks all arms of government and independent commissions and public institutions must lead to ensure that they incorporate a culture of public participation beyond the paper. And also, this will ensure that budget allocations from external public debt prioritize essential services such as healthcare, education, and critical infrastructure development. And on this, I would just wish to reflect that, yes, where we are and our public debt, our external public debt is not yet to a level where it can be considered more than what we borrow locally. However, we have to make deliberate steps towards that direction to ensure that we maximize the value. And here I would want to give an example backing it with my theory as I conclude that towards 2016-2017, we got aid from the Chinese government to build the standard gauge railway, which was launched towards the 2017 election. Now, it's in public domain that, yes, the public participation process was a bit limited, and even information relating to that contractual process is still very limited to this day. So why public participation? If we would have effective public participation, it will even give us an opportunity to maximize the kind of technology that we import from the financing partners that we get as we advance our development agenda based on public borrowing. Lastly, as I conclude, I would just ask us to consider this, that Kenya accepted a recommendation under Kenya's second Universal Periodic Review to develop a national action plan to implement the United Guiding Principles on business and human rights. That Kenya committed to develop a national action plan on business and human rights, a comprehensive strategy for protecting against human rights abuses by companies. And yes, we have a national action plan as we speak, runs from 2021 to 2025. And what I will ask all of us in this room is to appreciate these guiding principles and explore, because matters of business, matters of tax, matters of borrowing, they are related in a way. And I would invite us to consider the guiding principles for one reason. They provide us an adequate opportunity to get better ways on how we can be able to effectively adopt public participation. And it does this way through its three pillars, which is to protect, where it identifies the state's duty to protect human rights, and the corporates and businesses' roles to respect human rights, and finally, effective remedy mechanisms for victims or potential victims of human rights abuses. Thank you very much, and I wish to conclude my presentation from there. Thank you.
Thank you very much, Mr. Onyango. Mr. Onyango was my student in PTP. I had never met him because classes were online, he was an online class. So this is the first time I'm meeting him in person. And I'm thoroughly impressed. And those of you present here will agree with me, this is part of the reason why we support academic progression with a because Mr. Onyango here, sounds like not even a PTP, sounds like an advocate, a lawyer, thoroughly knowledgeable. So I'm thoroughly impressed, Chalo. We trust that one of these days we will see you in the PTP class here. All right, let's allow we have just about 10 minutes to 2 o'clock. We would like to end at just about 2. So for the next 10 minutes or so, we can take a few questions. Please move the mic. Just a few questions. Just say your name and say you'd like your question to be answered by Chalo or by Silas. Our participants on the online platform, you are still welcome to to ask questions, and our participants will be happy to answer them. Please proceed.
Thank you very much. My name is Kea, and I must admit that I'm equally very impressed by the presentation from Chalo. And like you've mentioned, yes, I think there is a whole challenge on that progression part, because we also get many, many queries as to how people can progress. But that was the debate for the previous discussion. I have about 2-3 questions. And the first one to both the presenters. And my question is, when we have our debt ceiling exceeded, or we find that we are getting ourselves into unnecessary public debt, where should the buck stop? And here I'm looking at the most radical proposal in terms of assuming it was, for example, the banking industry, we will go for the regulator, because we'll say, where were you when this happened? So in terms of the public debt, where should the buck actually stop? And if someone has to take responsibility, who is that person supposed to be? And with that, the next question to, I think, Mr. Chalo, is I saw you proposed that some of these issues should be debated even at the county assembly level. My challenge with that is, we have tried even legislating the debt ceiling, but you can see it is not really working. So you can imagine if we were to devolve that debate and looking at the caliber of discussions that happen at the national parliament, you can imagine the other caliber that happens at the counties. So don't we think we'll be making a bigger problem? Because what I have learned from my limited experience is that whenever we have an impasse in terms of legislation, people will be summoned somewhere, be it the executive or at the county level. And from there, that thing will pass even in less than, let's say, 1 hour. So that is my challenge. And then you also raised the issue of getting experts to probably help synthesize some of this information and give it back to the Society for Public Participation. Again, I'm asking if you can consider that when we have the Bretton Woods type of support, their aim is very different. They're in it to make sure that you get the loan. They are not in it to prevent you from getting it, because for them there's a benefit. I think you get what I'm trying to say. And when you are looking at, like for example, what happened in 2017 in terms of the election, we see that when we have civil societies engaged in some of these aspects, there's some backlash, because then we are never very sure which objective they are trying to serve in helping. Because they may be helping, but there's been a speculation or a fear somewhere that they have an agenda that they're trying to drive through their support. So I just wanted you to react to those. Thank you very much.
All right, thank you, Mwalimu. Okay. Please be brief and straight to the point.
Yeah. Thank you. My name is Otieno Bill. I have 2 questions, one directed to
Chalo
and the other one Silas. So I was keenly listening to your discussion, and you're talking about how our debt has ballooned, and just looking at how we had budgeted for projects such as the SGR and even the recently opened Bunge Towers. You see that the initial budget was very much lower than the one that was finally adopted. And most of the debts that we take, they end up not fulfilling the purposes for which they were taken. So can we first address the bigger issue
which is how are we really managing these debts, before coming and talking about how are we going to expand or widen the tax base in order to be able to finance our projects. Do we really need to, what is supposed to be our first priority? Is it dealing with the corruption and all other misappropriation of funds, or widening the tax base? And then, Chalo, thank you so much for your presentation. It was very nice. My question is this: what is the extent of public participation? Is it just making sure that people are aware that we are going to implement such and such policy, and we need you to come and witness that we are indeed going to go on with this law or policy? Or is it really listening to the inputs of what the citizens have regarding to a certain matter that is set to be debated on and be implemented? Or just, we are taking a recent example, matters to do with the social health insurance fund that whose act was passed, and also the housing finance, the housing affordable housing act, and we saw about 95% of Kenyans were really against that, and they carried a number of public participation meetings across the country. And the message from the Kenyans was that we don't want you to construct houses for us. But then you see that they listened to the views of Kenyans, but they went ahead and done what they wanted to do. So what is the importance of public participation if you already have made a decision that whatever you say, whatever you're going to say on this matter, it's not going to work because we have already adopted a final position on it?
All right, thank you. There's a hand there.
Thank you very much.
One more at the back, then we...
My name is Okongo. My question goes to the first presenter. What is your take on digital service tax in line with curbing tax non-compliance?
Okay, thank you. There's a challenge that Charlo threw to us, and I don't know whether you people noticed the question. He said there's a bill pending now before Parliament on public participation bill. And he asked us, has there been sufficient public participation on the public participation bill? A very interesting question. All right.
I have a question for, my name is Polika Pokumu. I have a question for Silas. You said that government should stop borrowing and expand the tax base. But recently, the government has rolled out e-Teams. E-Teams is an electronic tax invoicing register. So what the government is saying is everyone in business is going to issue electronic invoices which can be tracked by KRA. Everyone in business, it doesn't matter if you're making 10,000 or 25 million, every invoice, every receipt, everything that goes out has to be recorded by KRA. Do you think we have a tax compliance problem really in Kenya? And if you think we have a tax compliance problem, do you think there's a justification, an economic justification of collecting tax from everyone? Do you think the cost of, do you think the cost of collecting tax from every, let me just use the common term, every mama mboga will, meet the, will tally with the tax collected? And also recently the tax turnover rate has been raised from 1% to 3%, and the ceiling has been reduced. Yesterday, Kwame here was saying that we don't have a tax compliance problem. Kenyans do pay tax. The Kenya's budget is more than Uganda's and Tanzania's budget, considering the population of the two countries, like 100 million. David D is on public television saying our government is extremely wasteful. We have extreme travel. We have everyone using guzzlers. During Kibaki's time, he told his ministers not to use guzzlers. He told them to use Passats. How do you regulate extreme wasteful spending? Is it a political problem? Does it have a legal solution? Yeah.
All right, thank you. I did not see any other hand. Okay, I will allow last one, back there. Please make it short, direct, and to the point.
My name is Cyril. Most of the questions have already been asked by the others. I just want to make one comment on public participation and the use of the experts. We should fear there's an issue of experts and communicators. Is the possibility or having to put down these complex issues into simple way of communication. So what I'm saying, experts, but communicators.
Thank you very much. Yeah, that's a good point. All right, let me invite the presenters to now respond to this. Silas, you can go first.
Okay, good afternoon once more. I will wish to start with Mr. Kea's question. Where should be the debt ceiling stop? What maximum is maximum? That was your question. There's no maximum in setting the debt ceiling. What we really need is that the debt should be proportional to what Kenyans can handle, to what the government can handle. So basically, there is no maximum. The maximum should be proportional to what we can handle as a country. Yes. Okay. The parliament is mandated with the role to raise the public debt and the debt ceiling and everything. And the Public Finance Management Act 2012 gives the Treasury the duty to manage the sovereign debt and provide policies in which the government will use while trying to set the public debt. So who are we to blame when we don't use the debts that we borrow for the right purpose? And trying to answer this question, I will consolidate your answer with answering Otieno's question. Should we address the bigger issue of corruption first? So I think it has been an ongoing discussion. I think that as a lot of proposals have been brought on the table on who to blame on not using the public money the rightful way. I think we have to blame our leaders. That's the best thing we can do. Because these are the guys that we gave them the duty, the social contract, we gave the government the duty to exercise their authority in the goodness of the people. So they are the right people to blame. That's why we see EACC, Ethics and Anti-Corruption Commission, going past individuals trying to see why they mishandled the money. That's why we have the prosecutions with the EACC. So we call for individual accountability. What we can do now is really provide for proposals. We call for individual accountability. If you are caught misappropriating public funds, you are the person that have to answer the questions. Why did you approve this? So we call for individual responsibility. Otieno, we really have to address the issue of corruption at the same time as we are trying to expand our tax base. These are two issues that need to be addressed parallel to each other. We need more tax, we need more revenue, we need the government to generate more revenue, and we need the government to save more money by curtailing corruption. So we have to address these things at the same time. Okongo, what's my opinion on digitalization in curbing tax non-compliance? That's a good move. Kenya Revenue Authority will be able to trace each and every transaction that these companies make. long ago, when the companies used to make, the cash transactions, a lot was lost. KRA could not really know what amount they were supposed to tax. But digitalization of the taxation system will be able to track each and every transaction and see and drive a way in which KRA will tax as the transactions are continuing. So it will also broaden the tax base. Polycarp, do we have a tax compliance problem in Kenya? The answer is no and yes. It's double-sided. We have a tax compliance problem, but we don't have the tax compliance problem. I mean, some people are really willing to pay taxes. People are willing to pay taxes. Some corporations are not willing to pay taxes. It's double-sided. How do we regulate the extreme public spending? How do we regulate how these people use their sovereign debt? How do we regulate how these people are going to use the money they borrow on behalf of Kenyans to ensure that our debts are used for the right purpose? Goodwill. Principles of public finance, Article 2.1. Accountability. Our leaders need to be accountable. We cannot really force people or compel people, but what we really need from our leaders is the goodwill to do what is right, the goodwill to want to do what is right, not because of the personal interest, but because of the duty that the Kenyans have mandated these people to do on their behalf, the social contract. They should act on the best interests of the citizens of the Republic of Kenya. So those are the questions that I got. Thank you.
Thank you, and good afternoon once more. In responding to the questions, I'll begin by Mr. Cares, that the question on county governments, that yes, we want to get public participation to the counties, but we're already seeing all the troubles we're seeing with the counties. Mine is to ask us to be really optimistic in this sense that, yes, it's going 15 years now since we started with the county assemblies, but I think it's more of a teething problem. And part of the teething problem with the counties, in my humble opinion, is interrogating the quality of the leaders that we elect. Yes, we understand that it's not about the number of papers that are accumulated, fine, but at least a basic level of academic understanding of these concepts. I believe that will help us in terms of us as voters. Who are the people that are we electing? Who are the people we are electing, and how can we improve that? I think that can assist us. Why public participation at the counties is because of the unique challenges that some counties might be facing, which in the process can impact decisions made at the national level in terms of external borrowing. And so for that, I will say, one, we interrogate the kind of leaders that we have. Two, yes, we need to be optimistic about and trust our own processes that they can be able to work. There's a question you asked about CSOs and integrity. Maybe I did not get that well. I will request that we'll go back to that in a while. Otherwise, in addressing the question on accountability, yes, that is why that is in fact the reason why I was motivated to do this paper, that there is very little accountability. And this is happening because public participation currently is taken into account in the context of informing. Yet it leaves the other limb, which is consulting, because public participation should enable us achieve first, inform, then second, consult. Third, after we consult, we implement what we have consulted. So I would say this is more of our own culture and looking into ourselves and asking, what is it that we can do best to ensure that public participation is truly public participation, so that we stop this conversation where money was borrowed for Project X, but it went in to pay teachers, for example. And with more public participation, then that accountability aspect will be there. Then, so that it goes beyond the whole aspect of just having it as a cosmetic process or a process that is just intended to meet a minimum process. And just to give you another illustration, as I was doing my literature review, I came through a policy that had to be retracted by the National Treasury because of inadequate public participation. But I'll tell you, even when the document was taken back to public participation, that public participation was still not to that level. That's why, if you remember, in my recommendations, I asked us to reflect and think, is it possible to define it in law that we have a level or a threshold through which we can now say we have conducted effective public participation on a specific issue? Then lastly, I agree that there has to be a very good coordination between experts and communicators to ensure that this information gets to the target people without having it distorted and enabling it achieve its objectives. And this I support because the people that we work with, like for me when I'm not at law school, I'm usually conducting trainings in rural areas, and I agree that sometimes communicators do divert away from what the experts actually had intentioned. And that is for us in this room to even consider as work in progress, that as experts, when we are engaging communicators, how do we preserve our messages in a way that they can be able to enable us achieve our objectives? Mr. Kea, if you don't mind, your question, please, on civil society organizations. I did not get it well.
I think what I'll just say is
yeah.
We should be wary when we involve civil society, because sometimes they have an agenda that they are pursuing from external sources.
That is absolutely correct, sir. Thank you very much, Mr. Monique.
So thank you very much once again, our presenters. We have, like all the others, a small gift hamper for them. Isaac, would you like to please come over here? And just a small token of appreciation. All right, Santeni Sana. And that brings us now to the end of the formal part of the conference today. We now go to the closing ceremony, and I would like to invite Mr. Kuloba, the Assistant Director, Continuing Professional Development, Research and Projects at the Kenya School of Law, to now take us through the concluding part of the conference. Thank you, everyone, for your patience and for your participation.
Tumpigie makofi Mwalimu Mwaniki. Thank you. I would like to just say thank you to each of you for your being present, virtually and physically. The 2 days have been very fruitful, I believe. If we had time, we could have done some analysis of the issues, all the issues that have been discussed. Yeah, but the rapporteurs are working on the report. I hope we'll be able to share the report even as we publish the papers. As I said yesterday, we have very high quality papers. We have reviewed them before this conference. Now they'll also be finalized and reviewed further for publication in the shortest time possible. You all know that conferences are meant to generate ideas that can help to shape policy, to shape the law. And you see there are many recommendations, some very innovative recommendations in those presentations. Unless you share them, of course, these presentations will still be on YouTube and people will continue reading them. Even if we had just maybe 150 people participating at any given time, we know that people will continue listening to the presentations on the YouTube, and the message will sink. Policymakers are not just in formal places. Policymakers are also in informal places. They read these things and they pick up these ideas. For example, the legal education, the presenter, Mrs. Chweya, she asked for the presentations on legal education so that they can look at those issues that you have raised. And of course, the comments that have been given also will go towards enriching the presentations that have been made, and that's for the better. This theme, as we said, was chosen because it is very topical at the moment, public debt, taxation. We are talking about human rights, socio-economic rights, because when people make noise about taxation, it is nothing other than saying that we are feeling the weight of taxation, and that weight can only be felt if it is affecting our social, economic. That is the main aspect that can lead to that kind of issue arising. So we would like to thank the presenters for the job they have done to put together these materials, to do research, and to attend to present. So we thank you so much. You will be blessed for that, and we wish you all the best. Even I know some of you may be pursuing academic studies. Some of these things can also assist in achieving that. So I want to just give a vote of thanks to various people who have participated. As I said, the first people to thank is the presenters. We had, since yesterday, we had Dr. Makali Mulu, Vice Chair of the Budget Committee, Vice Chair Debt and Privatization Committee of National Assembly. We had Mr. Kwame Owino, the CEO, Institute of Economic Affairs, Kenya. We then had Mr. Nelson Dalila, Mr. Kinywa, and Mr. Otieno. We had Millicent, and we had Ikadi from NSSF and NHIF making their presentations yesterday. We also had Mr. Ndungu Collins, Ms. Nelly Maina, Ms. Bernadette Otieno yesterday, dealing with matters of taxation and human rights. So today we have had Professor Collins Odote, Chair of CLE, Mrs. Emily Cheya from the Office of the AG presenting on draft legal education policy. We have had Mr. Keya, who is still here, and Ian Morut. Of course, we have had Jiriri and Mburuku, Kialo Anyangu, who has closed the session this afternoon. So on behalf of the school and the organizing committee, we thank each of the presenters for their part. Secondly, we thank the participants. Those who have been here, we are grateful. We don't take for granted that you found time to come and be here, even if you had the option to follow online. Thank you so much for your sacrifice. The online audience, we thank you also because you have been very active. There have been questions and comments online. We really appreciate. We hope that we were able to answer all the questions that were raised to the best of our ability. We also wish to thank the various players within the school. We had a committee organizing this conference involving several departments like hospitality. They have been serving us, been taking care of this place. We have the corporate communication, arranging this deco, marketing, ICT, of course, finance, procurement. We thank all these departments. Together with, of course, ATP and PTP, CPD, we really appreciate because you have all been working together to ensure that this conference went on well. And also, on behalf of the management, of course, the director was here, who has ensured that everything flows as planned. In terms of organizing this conference, we had rapporteurs, Nasserian and Agnes here. Thank you so much. I know you have been taking notes to put together the report and the issues that have been arising in these sessions. And we have ushers who have been very helpful to assist us, the desk there, admin, moderators. Mr. Maniki, thank you so much for here. MC Anna Konuche was here yesterday. So everybody, thank you, Sam, if you have been here. Cornelius, I don't know where he went. He has been moving around so much. The principal officer, research and projects, have been very active in arranging this conference. So in short, we want to thank everybody. Our service provider, those who are ensuring that these proceedings are transmitted live, we thank you and we acknowledge your support. Thank you very much. I think things have been flowing very well throughout. Thank you so much. So just to conclude, if I have not mentioned your name or your category, just feel that you are appreciated, all of you, in the role that you have played. As a way forward, we said the conference papers will be published in the Kenya School of Law Journal. Will be inaugural journal, because we have been having a journal called Africa Constitutional and Comparative Law, which has been published by Juta in South Africa. It is available only in subscription. So this one will be a little different, and you'll be able to read those articles. I know they'll be refined to the editorial standards that we have. Otherwise, on behalf of the director, I would like to say once again, thank you. We'll ask each of you who registered with us to provide feedback. We'll send a questionnaire Please kindly respond to the short questionnaire. We'll just be seeking your views on various issues of the conference. We hope that we have addressed the questions. Of course, we will never be exhaustive. Taxation, national debt, socio-economic rights, legal education, those 4 areas, we hope that we have raised enough issues to excite us even to do more research in those areas. Just to mention that the school is mandated to carry out, to hold conferences. This is part of our mandate under the Kenya School of Law Act to do conferences, because this is where ideas are generated and utilized to improve welfare of the people and to improve even service delivery. So thank you so much. Can we clap for ourselves for what we have done? Let us do it in, how do you call it? 1, 2, 3, 1, 2, 1. Let's go. 1, 2, 3. Thank you. And for others who are not here, let us give them 2 factorial. 1, 2. Thank you so much. I would like to, after here, we go to the restaurant, all of us. We have lunch at the restaurant. After that, we'll be at liberty to go away or to remain around. I request my colleague Sam to come and pray for us as we close. You know, sometimes we pray for things when we want things. Then once we get things, we don't forget to thank God. Like the 10 lepers, only one returned to say thank you. The rest were too happy to remember the goodness that was done. So Sam, karibu. After that, we'll be able to disperse. Asanteni sana.
All right, we'll make our closing prayer. Yes. Yeah, Almighty God, we once again come before you with thanksgiving. Yesterday we prayed that as we start the conference, you'll guide us to go through it successfully, and we thank you that indeed we've seen everything run well. We therefore pray that even as we go into the rest of the day and the weekend, may you be our protector and our guide. We pray this in Jesus' name. Amen.
The Kenya School of Law was established in 1963 when a total of 11 students were admitted. From its establishment till the early 2000s, the school was located on Valley Road at the current University of Nairobi's Dental School. The school was a department in the Attorney General's office until 1995, when it was removed from that office and placed under the management of the newly established Council of Legal Education.
And after this, this position remained until 2012, when, as a result of a task force that had been established in 2006, the school was delinked from the Council of Legal Education by virtue of the Kenya School of Law Act 2012 and the Legal Education Act of 2012. So the Kenya School of Law Act established the school as an independent institution, whereas the Legal Education Act established the council as an independent regulator of